3/24 of 23.
Appeal stands allowed and all the appellants are acquitted from all charges.
Item 31, criminal revision petition 267 of 24.
Here petition is partly allowed. In fact, prayer for re-examination of PW10 is allowed. CW1 is not allowed. PW10 is allowed.
32, criminal petition 625 of 24.
Petition stands dismissed.
Any prayer for adjournment?
My lord, item 35 of supplementary list, maybe it may be after vacation.
35. 35. The request will be after vacation.
And it.
May I please, your lordship. Lordship, I beg to mention item number 6, madam. Well, this matter may be taken after vacation, madam.
Item number 6.
Item 6, yes.
It's a criminal petition.
Yes, madam. After vacation.
And the request will be asked after vacation.
No problem.
Yes, lordship. Lordship, if time permits, lordship, I beg to mention one unlisted motion matters, lordship. Okay, sorry.
May I pay a list for listing of a matter on third matter?
See what kind of
Criminal petition matter,
make
confiscation.
a mention before court number 11. Court number 11, senior bench.
That court is not sitting today.
Then talk to registry. What do they suggest?
This bench is taking into criminal petition matters.
May I please your lordship? Lordship, I am praying for the listing for withdrawal. Praying listing for withdrawal.
Withdrawal. Yes, when?
As per instruction of the party.
No, today.
No, tomorrow.
Tomorrow.
Yes.
No, court is tomorrow. It will be after vacation only. No way. Today is the last day of working day.
If possible today.
No, not possible. We are not listing anything.
For withdrawal, item 33 of the supplementary list.
Yes, you want to withdraw this.
My lord.
Is there any other prayer from your side?
No, my lord.
For liberty to fresh a file is
No.
not there. As per instructions, you have wanted to.
My lord, as per instruction.
You're for the petitioner.
My lord.
Your good name is M.
M.
Hawk. Order to Kuriba. It's disposed of on withdrawal. Okay, it will be disposed of on withdrawal.
Item 1,
My lord, page 66, same order, my lord. Page 66, same case.
Page 66.
Page 66 of my petition. Only page 66, same. Your lordship has already granted bail to the co-accused. Same, identical, only the name will be different. Page 66.
No, whatever. They want to submit, I don't know. You want to keep praying for bail today only.
My lord, your lordship has already
No, that I know. They will submit.
one your lordship has granted on 16/12, that is yesterday. And the other, that is at page 63/12. Yesterday only your lordship has perused.
No, that I cannot say. Let them say.
Acha.
Yes. How can I say?
It's not maybe call lordship. 10 days time allow us file our objection lordship.
You want to file your objection? No, I don't know. You can.
Now, my lord, will kindly see this. Yesterday only your lordship.
Yes, I can understand. You have submitted, but it isn't, if they want, then
Lordship.
Huh?
10 days time.
third,
lordship.
okay, please on third. By third, you can file objection.
And my lord, may I pray that because on third, the records of the case, if at all required, because my lord, in my submission. my lord,
Record may be retained then?
record, this application may be tagged with 3805. Because in 3805, which your lordship has disposed yesterday, already records were there.
That's what we record is
case-
even 3838.
Yeah. 434/2024.
434.
/2024.
This is the bail application
This is the
number.
bail application number which your lordship has already disposed of. The records are tagged in that file.
Record number, kindly tell us.
Record a NCB case number,
NCB.
NDPS case number 1/2023,
22.
pending before learned additional session judge number 5, Kamrup Metro. Already
We are going to retain this one.
Once your lordship, this bail application is tagged, the records automatically will come because the records are already there with this bail application.
Heard Mr. M. Biswas, the learned counsel for the petition. And also heard Mr. Enso appearing on behalf of standing counsel NCB. It is submitted by Mr. Biswas that the scan copy of the record is already received in connection with BA 434 of 2024 and accordingly prayed to take the application of 434 along with the present petition, which was disposed of on 16.
With 334.
No,
16, another if you fail your lordship. In that case, whether whether your lordship has perused the record, I'm not sure because it has not revealed from the order, my lord. But
Okay, then OTB tag with so wherein the record of NDPS case number 1/2023 was called for. List accordingly on third.
in the meantime, they may file their objection. If they-
Further, the respondent NCB may file their written objection, if any, on or before the next date of listing.
Understood.
Next, lordship.
34.
Lordship, I'm extremely sorry, Lordship. I was in the traffic, Lordship. I beg to mention, I think 42, Lordship.
42.
42, Lordship. Lordship, daughter of the conducting counsel, Mr. N. Hassan is unwell, Lordship.
N. Hassan.
N. Hassan. His daughter is unwell. Lordship, may kindly take up this matter after intervention.
Wait for an adjournment on appearing on behalf of Mr. N. Hassan. Submitting that he could not appear before the court due to his daughter's illness. List accordingly after vacation. Okay. Progress.
34.
Please, your lordship. It's architect matter, your lordship. Fix a date, LCR may be called for. And fix a date before 10 years, any date, 8 or 9. Already to 108 days behind the bar,
How many days?
108.
108.
108 days.
It's not a charge sheeted case.
Charge sheet.
Charge sheet. Yes.
The CBI counsel M. Hello is on legs kind of matter we passed over.
Okay. Yesterday also did some kind of things were happening.
Only LCR called, nothing is doing.
He will come in.
No, yesterday also same happened. In fact, he had to say, submit something. Just 45 minutes, he is coming.
Nice.
Item 2.
I have filed this criminal revision petition for cancellation of the bail order granted to the opposite party number 2 by the learned CGM Kamrup Metro. The order is at my page 133. Her relevant portion is at page 134. Now, can you see the second premise in the bail petition filed on behalf of the accused Nilam Medi, the learned counsel for the accused issued the notice, so he is not in this case. And on this count alone, my lord, the bail has been granted. Now, my lord, the opposite party number 2, my lord, earlier approached this court, my lord. And this honorable court, my lord, by an order,
Rejected, earlier rejected.
yes, my lord, and observed that by mistaking the court, my lord, he able to get the interim order that was subsequently rejected by the honorable court, my lord. And in that order, it was observed that 41 notice has been issued to him, my lord.
Mm.
But that is fine, my lord. Is page 114, my lord. My lord, relevant portion, my lord. Page 12, my lord. Page 109, my lord. 119, my lord. This is the submission of the, my lord, latter fee.
119.
Yes, my lord. This is a submission of a PP, my lord. The learned public prosecutor has pointed out that the IO has issued a notice under section 41 CRPC to Nilam Medhi, alias Nilam Kaisap, on 17/9/23, directing him to appear before the IO on so and so, but the petitioner has not complied with the order. It is also submitted in order to conceal his actual identity. Petitioner so and so has not disclosed the name of his father in the first title as well as the bail application filed by him. And ultimately, the court observed rejected the bail application. Page 122, my lord. Para 21, my lord. In view of the above, it is revealed that this interim previous bail was granted to the petitioner on misconception of fact that the name of the petitioner has not been reflected in the FIR. Now, what had happened, my lord, the opposite party number 2, my lord, is known as Nilam Medhi, alias Nilam Kaisap, my lord. And in the bail petition, my lord, he stated that the allegation is against Nilam Kaisap, not against the Nilam Medhi.
Oh.
That is the ground also taken in the lower court also, my lord.
Mm.
I have annexed the bail petition, my lord.
Mm.
Learned
Misleading the court. Huh?
Yes, my lord. The learned senior counsel for the petitioner obtained the interim order by misleading the court, which is definitely a ground for vacation of cancellation of the interim order. It also appears from the case that the petitioner has not provided the investigation. Despite the receipt of the section 41 and notice, the petitioner did not appear before the IO without showing any ground. Now, my lord, kindly see the his bail application in the lower court, my lord, page 129, my lord. Page 98, Nilam Medhi, son of Pramod Medhi. Here, he father's name is reflected, my lord. Now, in page 130, my lord, para 3, my lord. That the applicant begged to say that his son Nilam Medhi, the father has filed this petition, has picked up by the African police on so and so in connection with the above noted case. The arrested accused person is not a FIR name accused person, and he is not an employee of the Alice company. The FIR has been filed against the sister-in-law of the person arrested accused, namely Dipsika Sodori and Nilan Kaisap. So, he is the same one person, my lord. And para 5, he said that the 41 notice has not been issued to him, my lord. So, by missing the this honorable court and the lower court also, my lord, he able to get the order, my lord. And land court below, I don't know how, my lord, came to finding that Nilam's bail is granted to Nilam Medhi, alias Nilam Kaisap, my lord.
Oh, but bail order is alias Nilam Kaisap.
Yes, my lord. That satisfaction is not there, my lord. But at this moment, I pray, my lord, notice may be issued, my lord, and the case may be called for, my lord.
Case is not yet charged sheeted.
Not, my lord.
Yes, you can call it.
If I pray, my lord, for an interim stay of the order, my lord, because my the
Interim stay, that cannot, that cannot. Heard Mr. S. Botafun, the learned counsel for the petitioner, and also heard MSSH Bora, the learned additional PP, appearing on behalf of State President. Bakhi Likiba, this is an application, so and so, for consideration of bail later. Issue notice on respondents to registered ED and as usual process, no formal notice is required to be served on state respond number 1. However, copy or extra requisite copy may be served during the course of the day. Also call for the case diary You want any fixed date here in case
Lordship,
diary?
Hattigaon PS Lordship, after Bihu, after Bihu Lordship, we will get vacation on 23rd.
23rd. 2-3. Case diary.
Hattigaon PS case number 264/2020.
You have mentioned here, Hattigaon PS case.
Yes,
CD to Koriba, Hattigaon PS no steps.
264/23.
Okay. Fixing.
Yes, ma'am.
Take steps on for issuing notice.
Yes, madam. By raise suppose, madam.
Yes.
3,
Yes.
The revision petition, your lordship, against the order of the chief judicial magistrate, where earlier the petitioner hearing applied for quashing petition. They have filed a quashing petition. In the other side, the informant also came in reply, filed their reply, wherein they have stated they are not interested to proceed with the case. Thereafter, your lordship, if you kindly turn to page 34, is the order passed by the Honorable High Court, where direction was being issued. The operative part, your lordship, may find in the point number 11, page 37. Considering the submission of the learned counsel for the parties, it appears that the alleged offences except the section 294 IBC are compoundable in nature with the permission of the court, and the petitioners are directed to file appropriate application before the trial court that the matter has been amicably settled between the parties, and the trial court, after taking no objection from the side of the respondent number 2, that is the informant of the case, on proper identification with written consent, and dispose of the matter accordingly with his or her satisfaction, that the matter has been amicably settled between the parties, and the informant has no objection to dispose of the matter on compromise. Accordingly, the parties have approached the chief judicial magistrate. The informant himself, both are advocates. The petitioner is also an advocate and the informant is also advocate. They have approached the honorable court and they have given their, accordingly, the reply has been filed, petition has been filed, identity of the informant was also given therein. He personally appeared before the court. Even then, it has not been complied with and it has been fixed for appearance, Your Lordship. And the judicial magistrate asks for the appearance and evidence in this case. So we are asking for a clear order, Your Lordship, so that this order may be passed and may be compromised. Because the findings of the court, Your Lordship, may find it at page 47. No finding has been recorded by the judicial magistrate from the order of the High Court. There, page 47. The magistrate has recorded everything of the Honorable High Court, but has fixed for appearance, directly fixed for appearance.
No, you have not filed any proper compromise petition then?
In this revision petition also, Your Lordship, at page 39. Page 39 is the petition filed by the informant here. Informant himself appeared before the chief judicial magistrate. He has said that he is not ready with the, he is not ready to proceed with the case. And himself he has stated this thing before the chief judicial magistrate. Even then it has been fixed for appearance. The problem arises that the case is against the petitioner, that is the petitioner number 1 is the advocate, and petitioner number 2 is the wife of the petitioner number 1, and she is bedridden condition. This is the problem arises for the appearance also. For direction may be issued in regards to the case.
There was a direction from the High Court, in fact, now.
Yes, sir.
It has already been reflected in the order. I guess.
Yes, yes. And also, in the last part, only the record part is that it was previously fixed for appearance, it has again been fixed for appearance. Everything has been recorded by the court, but it has not, no finding has been recorded in regards to what understanding has been.
Now, the compromise is between Hafizur Rahman and
Petition number one, Inamul Huda, that is the petitioner number one. Petition number two is the wife of the petitioner number one. Both parties are not interested to proceed. Even then, it has been fixed for appearance and also for evidences.
That may be stay.
Mm.
Till regarding.
heard Mr. S. Ahmed, the learned counsel for the petitioner, and also heard Ms. S. H. Bora, the learned additional PP, appearing on behalf of state respondent. This is an application under section 438, 442, 442 BNSS against the impugned order dated, challenging the impugned order dated 3/12/2024, passed by learned CGM Nagaon in PRC case number 1720 of 2022 under section 341, 294, 506, 534 IPC. It is submitted by Mr. Ahmed, the learned counsel for the petitioner, that both the petitioners and the respondent number 2 earlier approached this court for that was a quashing petition for quashing of the FIR, for quashing of the criminal proceeding in connection with PRC case number 1720 of 2022, as the matter was amicably settled between the parties, and none of the parties are interested to proceed with the case further. On the basis of which, by order dated 28/10/2024, this court passed an order passed an order for
Filing appropriate application.
filing an appropriate application before the learned trial court below. The trial court below, and
Since the matter has been amicably settled.
as the matter has been amicably settled between the parties, and also observe that the section 294 is the only non-compoundable offense, but that can be compounded with the permission of the court. In person to that order, both the parties have appeared before the learned CGM Nagaon with an application for compromise between the parties. And the learned CGM had observed that the matter has amicably settled between the parties, and also reflected the order of the honorable or order of this court, that order of this court, full stop, the order of this court, that the parties were already directed to file for a compromise petition, file a compromise petition, as the matter has amicably settled between the parties. But in spite of that, the case was simply fixed for appearance, only with the view that the case was earlier fixed for appearance without assigning any reason. But your petition is not rejected also.
It has been not reflected here in your lordship. In the order, it has been maybe reflected in the earlier. They have appeared before the said petition. It has been reflected in therein, and I have filed the.
No. Your petition is not rejected otherwise.
No, it is not rejected. It is not rejected. No, it has been accepted, your lordship. Nothing has been.
But he submitted that the compromise petition, which was filed before the learned trial court below, is not rejected, but no order of towards its satisfaction is passed by the learned trial court below, and simply directed the parties to appear before the court as the case was fixed for appearance. Full stop. Mr. Ahmed further submitted that the matters have already amicably settled between the parties, and the petitioner number 2, who is in a bedridden condition, is also not in a position to appear before the learned trial court below on the day of appearance. Accordingly, he prayed for a direction to the learned trial court below to dispose of the matter on compromise. Next para. The learned additional PP MSSH Bora also raised no objection and submitted that in the earlier order passed by this court dated 28/10/2024 in criminal petition number 1199 of 2022 has already directed both the parties to approach the learned trial court below and to compromise the matter, as this section 294 is also compoundable with the leave of the court. Next para. In view of discussion made above, this court is of opinion that the matter that both the party opinion in favor of this, both the parties are accordingly directed to appear before the learned CGM so and so with a fresh application for compromise, and the petition may accordingly be disposed of on compromise by the learned trial court below in pursuant to order passed in criminal petition number 1199 of 2023 dated 28/10/2020. So you appear before the fresh application may be there in person to that order, it has to be compromised.
Have we disposed of?
Yes, disposed.
Item 4.
Item 4 is also yours. Yes.
This is a Zimma petition, your lordship.
What kind of
It's
Zimma?
a Zimma of a mobile phone, your lordship. Right?
Mobile phone.
Yes, Lord. So it is in the custody of the police since now it's been 1 year. So the last order. Lordship can.
10/9.
Yes, your lordship, page 19 is the interim order. Twenty-two. Only the IO has reported on Zimma Preda, it is stated in the report that seized mobile phone was seized in connection with this case and which contains several data and records, and the same will be required during trial and charge sheet of the case. And if the mobile phone is left in Zimma, it might hamper and tamper in the investigation. Only this is the report given, and whereas it is now within 1 year or so. And there are further orders from the Honorable Supreme Court also that such articles should be disposed of as quickly as
But
possible.
this is a case of what nature of case, this one?
This is a case, your lordship, under section 419, 420, 460.
But IT is there, na?
IT section is there, your lordship, but he is
That is the reason.
Yes.
not at all involved in this case. your
The
lordship. He was
involvement is
taken
otherwise,
into
but
custody.
the question is
Call
that
for a report.
the FSL, it has to send for FSL. I don't know whether it has been taken,
Yes.
steps has been taken or not. Should be sent before FSL, and if any data or thing is to be examined by the FSL, then it has
The
to.
report may be called for, your lordship, because this more than 1 year now, your lordship.
A report we call for from the IO in regards to Zimma of as to whether the mobile, as to whether the seized articles, namely mobile number to DD, so and so will be required for further investigation or not. And in the same time, it is also to be reported that whether the said mobile handset has already been sent for FSL examination or not. IO is accordingly asked to give a detailed report in this regard. list, when it can be listed?
So any test as per the convinced.
Obviously after vacation, after view vacation only.
Yes, on 29th.
29. 29, 5, 1, sorry, 24. Okay.
Okay.
Item 5,
I have Your Lordship.
Yes,
Madam, this will revision petitions challenge the order dated 9/7/2024 passed by the Session Judge my lord in criminal appeal law in where dismissed on contest of rupees 5,000 payable to the accused petitioner to the complainant and upholding judgment and order of conviction passed by the learned SDJM Nazira my lord.
it was upheld.
Yes, my lord.
Say a night metro action, not issue.
And I,
Yes, my lord.
okay, we are issuing notice here and we'll call for the LCR.
There is a I, my lord,
I is for,
stay, my lord.
otherwise you are on, still on bail, a jail, what is,
Bail, my lord.
you are on bail.
Yes,
Previous bail was allowed?
yes, my lord.
Have you annexed any kind of order that your previous prayer, bail prayer is allowed?
That order was not annexed, my lord.
At the time of filing the appeal, whether there is any order? Now, how can we say that he is on previous bail?
Yes.
Nothing is there before us. Oh, just find it out. Do you have any instruction that it has already been sent back, the record has already been sent back to the learned trial court below or the SDGM? And whether any steps has been taken issuing,
Give me some time, my lord.
okay, okay.
After some time, my lord. Yes.
time being 34,
Please. Substitute matter, Your Lordship, shall be rejected, such LCR may be called for fixing the date of 8 or 9.
Yes.
This honorable court has already rejected the bail application and charge sheet has also been filed. They subsequently filed a petition before the honorable court below. They are also on merit, it was rejected.
LCR may call for 8 or 9 any day. Base 109, 8 days behind the bar. So I could order release of the bail by this court.
Co-accused was released on bail.
Failure. Prior to filing substitute,
Huh?
right? Prior to filing substitute by this, Your Lordship.
Now it is charged to.
Yes, substitute. And trial court rejected after substitute. LCR may call for.
Here also you want to file any objection?
Yes, sir.
Heard MSS Islam, the learned counsel for the petition, and also heard Mr. M. Halu, the learned special PP CBI. Call for the LCA, scan copy of the LCA. Further, the respondents CBI is hereby. No, further, Mr. Halu, further to file the written objection. They are allowed. List the matter accordingly on. It will be listed after vacation. We cannot fix any date. Huh?
8 or 9, Your Lordship, because
8 or 9? No, 8 or 9 is not
only
possible.
108 days behind the bar, because of the release.
What to do? After view vacation, you submit any date. When can it be closed?
22nd.
22nd.
20.
22nd students. So in the meantime, the respondent may file the return petition. Okay.
Seven.
May I please, your worships.
Yes.
In 125 proceedings, my lord, the respondent number 2, that is petitioner's daughter, was granted, my lord, the maintenance allowance. Now she attained majority in 2022. Then the petitioner filed a petition before the family court that she has attained the majority, so she is not entitled to get maintenance under section 125. Now, without hearing and without any petition, this imping order has been passed that yes, under section 20 of the Hindu Maintenance and Adoption Act, it can be granted maintenance to the unmarried daughter till married. It is not disputed, my lord. Now, question is that, my lord, no application has been filed by my daughter who has attained majority under section 20. And without any application, without any hearing, this imping order has been passed. That is as page 34. Relevant page 38, paragraph 9. It is not disputed, my lord, she is not entitled to get maintenance under sections 23 of the Hindu. Page 38, paragraph 9.
Just a second.
Right.
You will file it before appropriate bench. Any other appropriate bench without me.
Lordship was right.
List before any other appropriate bench without me.
Applies.
Item 8.
May I please, Lordship, in this matter, Lordship, I filed a criminal petition for challenging the learned CGM order, Lordship, some wrong findings, Lordship. After filing this revision petition here, Lordship, earlier. Lordship, first, Lordship, kindly come to the FIR, Lordship, page number 23, Lordship. This is the complaint from the police, Lordship. Lordship, what happened,
Complaint from
Lordship, in
the
the different?
police?
Yes, police filed this FIR, Lordship.
Acha. So what?
earlier.
Acha.
Lordship, earlier, what happened, Lordship, there are so many colleges in the Borpeta district, Lordship. Some Ishanuddaya scholarship zona is the one of the main allegation, Lordship. Some anomalies in the scholarship is happened, Lordship. There are so many colleges, Lordship, not only petitioners college, Lordship. But in the FIR, Lordship, there is specific mention the different college, Lordship, Bongaigaon College, DB College, Lordship, Kolkata. Kindly see the FIR, Lordship, in the last portion. Here is the college name mentioned specifically, Lordship. These are the colleges where anomalies took place, Lordship. Once happened, Lordship, the Uttar Borpeta College, the principal, the present petitioner is the principal of Uttar Borpeta College, Lordship, with the government college, Lordship. What happened, Lordship, in suspected grounds, earlier he was arrested, Lordship, the principal, Lordship. Although there is not a single amount of scholarship is coming in the name of this college, Lordship. I will later on show the documents, Lordship.
He is a principal of Borpeta College?
Uttar Borpeta College.
Uttar Borpeta.
Yes, Lordship.
Hmm.
In the after filing the charge sheet, Lordship, there is not a single allegation against the principal, Lordship. Lordship, after arresting, Lordship, the page number 25, learned CGM itself allow him to go on bail, Lordship. And in the bail order also specifically mentioned, there is nothing recovered from the petitioner, Lordship. Kindly see in the last portion of the bail order, page number 25, Lordship. Where is it? Insufficient introduction and also nothing recovered from the above name accused person, Lordship. This is the bail order where CGM itself earlier declared that there is nothing recovered from the petitioner. Thereafter, Lordship, after arresting, Lordship, the petitioner also suspended from the post, Lordship. Thereafter, this Honorable High Court also reinstated him. The page I have annexed the page number 29, Lordship, the reinstate order by this Honorable Court, Lordship. After reinstate, Lordship, he again joined the post of the principal, Lordship. Now he is working, Lordship. There is no any difficulty there. What happened, Lordship, though the trial proceeding was started earlier, Lordship, because there is a charge sheet earlier filed, Lordship, in the different college was engaged with this allegation, Lordship, and trial proceeding also going on, Lordship. In the meantime, Lordship, page number 33, Lordship, one additional charge sheet was filed, Lordship, by the police, Lordship. The parts are charge sheet, Lordship, main part is the page number 35, Lordship, the charge sheet. In the supplementary charge sheet, Lordship, the name of the petitioners, Dr. Zeher Ali, the principal of Uttar Barpeta College. The name was mentioned in the page number 34. And next, Lordship, page number 35. Here is the clearly stated, Lordship. If the Lordship is second paragraph, Lordship, page number 35 in the charge sheet. It is to be mentioned that the FSL report and the report from the UGC head office, Delhi, requiring information and documents regarding the scholarship has been, and report from Director, Shore Area Development and State Nodal Officer, Guwahati, yet to be collected. Lordship, this clearly mentioned the report yet to be collected, Lordship, not yet collect that report, Lordship. The main question is, Lordship, the whole allegation is based on the scholarship, Lordship, and the sole authority is UGC, Lordship. Scholarship, all scholarship, Lordship, fund is come from the UGC, Lordship. I'll show another letter, Lordship. One UGC letter, Lordship, kindly see, page number 49, Lordship. Page number 49. The letter from the UGC authority, Lordship. Because the allegation is limited, Lordship, only on the scholarship scam, Lordship, and scholarship sanctioned by the UGC authority only. And the UGC authority clearly mentioned that in the same year, specific.
Yeah, earlier.
Yes,
charge
I'll
sheet-
go on that.
yes,
Lordship.
Earlier charge sheet, you were not charge sheeted.
No, not
But
charge sheet.
second, the supplementary prayer was there, and then you
yes,
got
yes,
charge sheet.
my-
Then,
My charge sheet is there. Lordship.
mm,
And this is the scholarship, or sanction scholarship, or everything from the UGC, Lordship.
obviously, it from
Yes,
UGC.
UGC, yes, Lordship. Now, earlier we filed a criminal petition before Dishonored court, Lordship, where we seek for reinvestigation and because the charge sheet is defaulted charge sheet, Lordship. And this honorable court passed an order that you approach before the learned CGM appropriate authority, the CGM under section 173 and subsection 8. Thereafter, we approach before the learned CGM, Lordship. Learned CGM passed an order, Lordship, page number, this is the annexure 9, page number 43, Lordship. Here we challenge this order, Lordship. I'll come to the finding only, Lordship, page number 46, Lordship. Page number 46, last portion, Lordship. The learned CGM considered, Lordship, that in the 2021, 22, and 23, there is no scholarship scam is there. But learned CGM come to a wrong finding that the last paragraph number 14, Lordship, the SR further show that the alleged offense started in the year of 2018, Lordship. Lordship, kindly come to the FIR, Lordship, where specifically mentioned that two person was outsider of the college in another college, VV college. They just mentioned that we started the offense from 2018. But not a single allegation against the petitioner's college and against the petitioner. In the charge sheet also, Lordship. A principal, Lordship, is now.
Okay, then it's a detailed order has been passed by the learned CGM
Yes.
for your rejecting your prayer.
Yes, Lord.
So we are
Lordship,
going to
record
issue
will
only
be called
notice
for-
only, and we'll call for the record.
Lordship, in the meantime, Lordship, because the trial against me, Lordship, not yet started, Lordship. But after this order, it will be started, Lordship. Because earlier proceeding is going on against the main accusers.
We're not going to stay any order.
Lordship,
It's a case of thing,
I
yes.
have not found any illegality. in
No,
state
no,
order.
nothing is there.
Lordship, kindly come to page 46, the last portion.
Yes.
Because
it
the
did.
Jahar further shows that the alleged offence started in the year 2018.
Yes, it started from
Whereas
18.
the petitioner has submitted documents showing that he approached the UGC in the year 2023 only. So how can it be acceptable?
FIR is
Which is the next
2022.
page number, Lordship.
Now see 20, 21, 22, these were the processes
I mean,
were
that's
going on.
Yes,
But
yes.
in 2018, there was a scheme. There was I mean,
Yes,
scholarship.
But so far as a clarification from UGC here submitted
Yes.
by the annexer 12 Lordship at page 49,
Ah.
that there is no relevancy. It's not relevant at all. Lordship.
No, no.
I found no
You may
legality
call
in the
for
state
if
order.
any allegation
Lordship,
against the
so-
principal lordship. Otherwise, yes, there is no any allegation. Why?
Notification, otherwise,
Page the-
so now here it is seen. Earlier in the investigation, there may not be some materials may not be collected by the IO, but subsequently it was being collected.
Yes, Lord-
And that's why charge sheet is filed.
Lordship
And
may
now
call for.
cases of 2018 wherein this scam was there in fact. And it is of the process you are filing this 49.
Yes, Lord.
She is rightly submitted that a 49 is nothing. It is 2021 process was going on for
Yes.
your scholarship schemes. But it is of 2018 wherein that was happened.
Yes, Lordship may
That
call
is the
for.
case. That is the
Lordship
case.
may call for the record, Lordship. If
collecting the case
anything,
record.
any finding come up against 2018, Lordship. Lordship,
Definitely we
that-
call for
that
the
will
case
be
record.
Lordship. In the meantime,
Can't
Lordship,
do it.
the proceeding may be stopped.
No,
That's
not at
it.
all. No question doesn't arise. You are Mr.
You want.
A. Ahmed. Short quote over heard Mr. A. Ahmed, the learned counsel for the petition, and also heard MSSH Fora, the learned additional PP, appearing on behalf of state respondent. This is an application under section 528 of BNSS for setting aside and quashing of the impen order dated 18/11/2024, passed by learned CGM,
Additional.
learned additional CGM Borpeta, whereby prayer for deleting the name of the present petitioner from the supplementary charge sheet was rejected, which was submitted on 6/5 of 2023 in connection with GR case number 1994 of 2022. Issue notice. State is the only party here.
Yes. State.
Issue notice. However, no formal notice is required to be served on the respondent, state respondent. The copy of the requisite extra copy may be served during the course of the day. Call for the scan copy of the LCR along with the case diary. List accordingly after vacation. After 4 weeks. List after 4 weeks.
Item 9.
Wait, please, your lordship. Lordship, here the petitioner is agreed by the order dated 9/8/2023. That is NXR 5 document. Where in page number 46, lordship.
46.
46. It is a case related to NIA lordship, here the lower court has convicted the accused person and he has filed an appeal, lordship. And by this order, lordship, it was directed to deposit an amount of 20%. Lordship, he is deprived by the order because prima facie there is no case exists, lordship. I am coming to the complaint petition, lordship.
No, you are on the fact that the 20%.
Yes,
is the
20%.
issue.
I am deprived by the 20% because 20%. Court should not have passed the 20%. Suppose in the judgment also it has been clearly said, lordship, I have to come back, lordship, because in the complaint petition, the complainant stated that 2 checks were given and 2 checks were bounced and notice were sent. A check that is mentioned in the complaint petition is totally wrong. That check was not bounced. That check was not bounced.
2 checks were not bounced.
Two checks were bounced, but a check which was bounced, it was wrongly mentioned that in the evidence, lordship. May I come to page number 15, lordship? The next one is the complaint petition. CR case, Lordship. CR case. It has stated that to discharge of the lawful duties, the complainant the accused person number 1 issued and handed over the complainant under mention on checks drawn on SBI. Lordship, the checks numbers are mentioned. And against these checks, notice was issued. But in the evidence, they have produced a different different check.
These are not the checks.
One check is there, but other check is not
Disputed.
there. They have produced a different check. And when against this complaint case, the present petitioner was convicted. Also, he has filed an appeal, criminal appeal number 413/2015, page number 18. Page number 18.
Yes, this is the appeal.
The appeal, Lordship. Here in the appeal, the petitioner has taken a ground that is page number 19, Lordship, 6. Point number 6, Lordship, in page number 19. That the learned court failed to take into consideration consideration of the fact that bank return memos stated about a different check which was bounced and not the check upon which the complainant petitioner has filed the case. So there is a different check. So the evidence they have produced a different, and it is very much clear that prima facie no complaint case exists. Lordship. Here, the learned court high judgment. This is the judgment in criminal appeal number 41/3, Lordship, arising of the same case. After going through the records, Lordship, page number 21, Lordship, 6, 7, Lordship, page number 21. Also, there was an observation made that from perusal of exhibit 2 and 3, it appears that the exhibit 2 is the compared copy of the check number 172009 for rupees, but that exhibit 3 is not the check number 172218. That is mentioned in the complaint, but it is check number 172210. They have filed a defined exhibit. Total the nature of the case changes because that check was not bounced and neither for that check notice was issued. It has been observed, coming the same page, point number 9, second paragraph, from the perusal of it appears that exhibit 5 is the compared copy of the demand notice alleging dishonor of check number 172009 of rupees dismissed and check number dismissed. From the evidence on record, it appears that the complainant from the beginning of the case, since filing of the complaint petition, mentioned about dishonor of check number 17209 and 172218. He is in his evidence on affidavit and also in demand notice mentioned about the two checks, that is check number this and the check number 172218. But in the course of the trial, failed to produce the check number 172218. The complainant also failed to prove the dishonor of check number dismissed. That was an observation made, and later on, Lordship, there was discrepancies in the trial, Lordship. So in the appeal, it was remanded back on the condition, Lordship. There were some conditions put, Lordship. Some evidence was also missing, Lordship, in page 22, para 13, Lordship. It is submitted, page para 13, learned consumer appellant submits that learned court passed the judgment on the basis of inadmissible evidence. Hence of CW2, Anjani Kumar Joshi, it is submitted that from the order dated 3/11 dismissed and passed by CR case, it appears that the evidence on affidavit of PWT on went missing from the record of the court, and the Linehead Court accepted the photocopy of the affidavit, relied on the said photocopy, Lordship, photocopy affidavit, passed the impugned judgment, Lordship.
So it was remanded back.
It was remanded back.
Then
Remanded back. Impugned judgment and order direction, fresh trial to conduct, and after taking necessary steps with regard to the missing evidence, Lordship dismissed, and after examination of the to deliver a fresh judgment, Lordship. From the fresh trial, it should be conducted a fresh trial.
then fresh trial conducted.
A fresh trial conducted, but fresh trial not conducted in a proper manner, not the fresh trial conducted, because Lordship,
And whatever fresh trial was there.
fresh trial was there, but not from the beginning, because Lordship, then
Again, you
fresh trial
are convicted.
also convicted.
Again convicted.
Or again convicted. That is Annexure 3, Lordship, page 24. It starts from page 24, Lordship. Lordship may come to page 27, Lordship.
You want to say that
27.
those were not considered and it was again convicted.
Again convicted. Lordship, page 27, it says there was an observation by the Learned Court that proper amendment or what should be done, procedure also not followed, the proper amendment also not. Lordship, a year after the case record was remanded back, the complainant filed an application for amendment and prayer to amend and correct the check number dismissed. Demand notice also they tried to correct and complaint petition and initial deposition. Lordship, only regarding to the amendment, regarding to the complaint petition was allowed. Lordship, but that amendment also not done.
That amendment was not done.
Not done.
Hmm.
There is an observation, Lordship, not done. Lordship. Page 32, Lordship. Court has observed that amendment also not done. On the same set of complaint petition, again convicted. The page 32, Lordship. Page 30, para 13, Lordship. During the argument, the accused counsel argued that although an amendment was allowed to correct the typography made in the complaint regarding check number, that same was not made. In the case, has mistakenly mentioned one digit in the complaint, but the check number was correct in the exhibit. However, in notice, check number was different, typographical error, but no, Lordship, I have perused to the order dated dismissed.
The question is that it was wrongly typed or mentioned in the complaint petition, though the proper check is of different, and
Yes, that
was considered by the court.
Lordship,
It was merely a typographical mistake, in fact.
Lordship,
That is the view of the court.
Lordship, because the time is considered, Lordship. On this basis, Lordship, if a check is found within a limited period, Lordship, notice should be issued. Notice was not issued to me. On the check number,
You
that
have
was
taken
found.
already, I think. Those pleas you have taken already. In spite of that, it's second time you got conviction order.
In spite of that, mechanically, it has been passed.
Now, I don't have much time. Now say what is did then.
It has been made, Lordship, observation, no amendment subsequently.
Now why you're here first? Just
Lordship, 20% should not be passed because there is an exceptional circumstance where there is no prima facie
what kind
case.
of circumstance? Exceptional?
Lordship, because the prima facie there is no case against me.
That will come later on. And the appeal it will come. But the
Lordship,
question is there any other circumstances which you are prevented from paying 20%?
Lordship, the
No,
court,
I don't think so.
Lordship, the order dated 8/7/2024, Lordship, it was passed without hearing in our side, Lordship.
Without hearing your side? You are the appellant, isn't it?
Yes, I am the appellant. Observation, the order clearly reflects that no. Lordship, observe, the order clearly reflects, Lordship.
No, after amendment, this is the 148.3, this is the
After amendment, the amendment was not made. Lordship.
No.
Interestingly, the amendment was not made in the.
No, amended provision of NI 143A is there, no.
Lordship,
That's why it is passed.
I will rely on the judgment of Jambu Bandari, Lordship.
They are not going to hear this one. It's not the hearing stage. Now, what the prayer here? Your prayer?
My prayer is, Lordship,
Offense.
the order dated Christmas maybe was, Lordship.
Washed. Heard Mr. J. Sharma. We are on. J. Sharma, the Learned Counsel for the petitioner. This is an application, so and so. Issue notice to the respondent to register DD in as usual process. Also call for the appeal is pending, na?
Appeal is pending.
Call for the মানে এটাতো নাই এটাতো হে আছে scan copy of the LCR যেটো appeal number আছে যেটো other one to appeal number 22/2/2023 criminal appeal pending before the learned session judge Sibsagar. We'll need the next date of listing. The order dated 8/7/2024, passed in criminal appeal number 22/2 of 2023 state. List accordingly after vacation.
Okay.
Item 10.
May I please amend? Responding to laws and affair.
28 motions. Again, 3 other motions. 30-35 motion delay again have a sort of for submission.
Yes, sir. May I please? Also, responding to laws and affair, case 21 lawsuit. Yes. Allegation is that on 21 so my son Tanur Haq came with one Aminul Haq, son of so for doing building work in the house of the below named person, and on last 24/0/2017 at about so while working in the said building in the top floor suddenly fell down and grievous hurt, though he was admitted taken to the Sagat hospital so but died due to illness so disease. So this is the FIR, Lordship. After that case is registered under section 304. During investigation, police submitted final report, Lordship. Thereafter, notice was served to the informant. Informant turned up before the CGM court. There filed objection, Lordship, which is in case 28, Lordship. Objection by the informant. Annex 5, page 28. In para 4, the informant believes that investigation was not properly done. The investigation being returned unfair, untainted, undesirable, on being based on no truth, has not satisfied with the investigation done so far by the police. As such, the informant by appearing before the court, honorable court begs to submit that has objection if the matter may be closed, that it is pertinent mention here that honorable court may allow to further investigation of the instant case. So after this objection petition, Learned JMFC to Cognizance against the present petitioner. That order is, Lordship. Page 30, Lordship. Police submit a final report, but page 30. Case record is received on transfer from the Honorable Court of CGM Bongaigaon for disposal. Peruse the case record and charge sheet, Lordship. Police furnished final report. But while taking this order, Lordship, I maybe oversight, case record, then charge sheet, Lordship. Paragraph material understand CGO for IPC Act is made out against the accused person. Thereafter, cognizance is taken against him under the aforesaid section so and so issue summoned to the accused, Lordship. So cognizance is taken against me, Lordship. Thereafter, Lordship, case 31, I appear, case is cancelled, section, Lordship, I appeared, I have taken bail, Lordship. Thereafter, Lordship, I filed a petition under set 227 for discharge from the charge, Lordship. This is page 34 is the petition, and
So
227
this cognizance was taken
by.
after your, after complaint made by the, after your
Yes.
objection made by the complainant.
No, sir, objection made by the informant,
Ah.
then cognizance is taken. Page 30.
That is, it is not not only the case that is only based on the charge sheet, the cognizance was taken. In
There
fact,
is no charge
cognizance
sheet,
has
sir.
taken.
There is no charge sheet, it is final report.
Yes, final report.
Yes, yes.
It's not the case that final report, on the basis of the final report, the cognizance was taken.
Yes.
In fact, cognizance was taken after
objection.
hearing the
Objection,
complainant and
yes,
the
yes.
objection.
Yes, Lordship. Then I filed a petition 227 before the session judge for teachers. That also rejected. That is order, Lordship, page 43, Lordship. Order of the session judge. Lordship, 43, last question. Thereafter, after receipt of the FR from the court of CGM Bongaigaon, notice was again issued to the court, from this court to the complainant, and thereafter on 22/4/24, complaint appeared before this court and filed objection by petition number so and so. 44, Lordship. Hence, considering the objection regarding discharge of the accused given by the complaint, the prayer for discharge as filed by the accused is rejected. That is rejected by the session judge, Lordship. Now, I am coming, Lordship, page, coming. The place of occurrence and date of occurrence. I am doctor by profession. Enter building belongs to my father. I enclose the building copy, that is in Annex 1 and 2, Lordship. The property building belongs to my father, Lordship. Page 18 is the landowning certificate. The land and building belongs to my father. And 19 is the next 20 is the building permission. And Lordship, the place of occurrence and date of occurrence, that is in Annex 46. I was in outside of India, Lordship. I had a program, Lordship, page 47 on 22nd March. I was in South Africa. The document I enclosed and returned from there from on 25, Lordship. So that is nowhere related with me that I was involved with this accident, Lordship. Property building belongs to my father. And on the place of occurrence, I was in South Africa, my document enclosed, Lordship. I had a meeting, Lordship. And 46, that day I left from India in Mumbai.
How you related then?
Yes, Lordship. That is the reason a final report has been submitted. Final report submitted to the police.
It was a building construction.
Yes,
construction
construction
was
going on. Yes, labor was working. And building belongs to my father's name. And so far the section 304 is concerned, it is nowhere comes with me, Lordship. I explained regarding 407 page 12, Lordship. What is 304, Lordship? Yes. 304 punishment for the couple of homicide not amounting to murder. Whoever commits couple of homicide not amounting to murder shall be punished with imprisonment for life or imprisonment of either description for a term which may extend to 10 years and shall also be liable for fine. If the act by which the death is caused is done with the intention of causing death or of causing such bodily injury as it likely to cause a death, Lordship.
Yes.
Yes,
Laura.
So far as the FIR is concerned, direct allegation against a petitioner.
And it is not a case, I think, for 304, in fact. At best, 304A may be there. This construction site, there may be some negligent thing is there, for which he may fell down and got hurt. That may be the case, but it's not a 304, I think. So now what is the stage of the case at present?
No, now it is fixed for consideration of charge before the session judge, Lordship.
You are the only accused?
I am not. Father died. I enclosed the death certificate of father, page 45.
Who are the contractor of the building also?
He already left. After the incident, they took some money from me and the construction is over, Lordship. He took some labor, Lordship, who fell down from there. And my mother, they took the patient to the hospital, Lordship. In the FIR, they itself is mentioned, Lordship. I am no related. I was in abroad, Lordship, for my training, Lordship. That is the case, Lordship.
Did returnable debt, Lordship.
Mr. DJ, the learned counsel for the petition. And also heard MSSH warrant, the learned additional PP appearing on behalf of state respondent. It's an application at section 528, read with section 438, so and so BNSS. For setting aside and quashing of the order dated 5/10/2024. Passed by Honorable Session Judge Bongaigaon in connection with session case number 47, BGN of date 2022. Under section 304 IPC, which is pending before the learned session judge Bongaigaon. Issue notice. The state is the party, I think. Number 2 le patha, no formal notice is required to serve on respondent status for number 1. Also call for the scanned copy of DLCR. Next, considering the submission made by the learned counsel, Mr. D. Further proceeding in respect of the present petitioner will be stayed till next date of listing. List accordingly after 4 weeks. Short. Notice.
11.
Leadership, this is a petition where I'm seeking quashing of a criminal proceeding pending against me under 498A.
Hmm.
Now, the marriage between the petitioner and respondent number 2 before your leadership was solemnized in 2009, December 2009. A child was born in 2012, who is currently in my custody, pursuant to intervention of this honorable court in a habeas corpus petition, where actually, where the crux of that particular case is that the respondent number 2 indulged in child abuse, which ultimately resulted in a complaint by the Child Welfare Committee against respondent number 2, and custody was given to me. Now, a divorce petition, your ladyship, was filed in March 2021. This is very important. Your ladyship will find that at page 37, March 2021. The date is crucial.
40. Page number?
Page 37.
37.
37. It starts at 37, and the date your ladyship will find at page 45, March 2021. Ladyship has it.
Yes.
Now, immediately thereafter, on 12th of May 2021, the first FIR is filed by the respondent number 2. Ladyship will find the complaint based on which the FIR was registered at page 47. May I read your ladyship? Page 47. The typed copy is at 47. The true copy is at 50. Handwritten is at 50. May I read the handwritten? It's clear. To the officer in charge, Dibrugarh Police Station, so and so. Respected sir, with reference to the subject cited above, I, the undersigned, would like to inform you that my husband named Arvind Kumar Khemka, son of so and so, Kolkata, presently at Banaras, started to torture me mentally and financially with immense continuous threaten and abuse since many days, to the intent that I was out of the house along with my 9-year-old daughter, and having no alternative. This is important. And having no alternative, I came to my paternal house at Dibrugarh. But here already he had created such blackmailing atmosphere of the society along with materialistic pressure that I was on road on June 3rd at 9 p.m. on a curfew day with a girl child completely at risk at that hour, took shelter at a local city hotel. Recently, I had come to know that since last 2 years, my husband has been in an illicit relationship, because of which he has made my and my child's life miserable. To give it a last try to make the things work, I will go home. I therefore request to keep the above information as record for future reference, for which I shall be highly obliged. Thanking you, so and so. Incident reported at the last as the last cruelty happened in Dibrugarh, Assam. Now, nothing is insofar as cruelty is concerned here. All that she mentions is that she came back to the parental house and I created a blackmailing atmosphere, whatever that means. I created a blackmailing atmosphere, and ultimately she was stranded on the road when she was in her paternal home. This is full of contradictions, your ladyship. But be that as it may, this was followed by 3 more FIRs. Total 4 FIRs have been filed against me. The second FIR, your ladyship, is dated 23rd September 2021, which was filed in Varanasi. The date is important again, 23rd September 2021. There, she tries to improvise her allegations
And your ladyship will find the, and your ladyship may just note the page number. Page 55 is where the crux of the allegations are. And this pertains to Varanasi. The second FIR is in Varanasi. The third is in Kolkata, in Karaya police station. Fourth FIR is again in Dibrugarh.
First was it?
First one was in Dibrugarh.
Second was in Varanasi.
Second one was in Varanasi.
And fourth one is
Third one was in
Kolkata.
Dibrugarh. I'm sorry. Third one was in Dibrugarh. I'll give the date also. 12th May 21 is the first FIR. 23rd September 21 is the second FIR in Varanasi, Marwari police station. Then the third FIR is on 24th October 2021. This is in Dibrugarh, third one, where she substantially improvises her earlier allegations. And the fourth FIR is 18th November 2021 in Karaya police station in Kolkata. Now, two very crucial developments take place. The police in Karaya gives a closure report which is accepted by the learned magistrate, not contested by her. I have enclosed that your ladyship will find at page 85. I'm just reading from the paragraph after the paragraph that starts with brief facts of the case, page 85. In fact, I'll read from brief facts of the case. The FIR named accused person being the husband of complaint subjected her to torture both physically and mentally on and before 13 November 21, and the issue of family dispute and also misappropriated Sridhan articles which were gifted by her parents and relatives at the time of marriage and criminally intimidated her, and also the accused person threatening her daughter, namely Aditri Khemka, to give false evidence against her. During investigation, examine the witness and so their statement, and it could be learned that over the issue of matrimonial dispute, the accused person left his residence, but every month he pay household articles, flat rent, other expenses to his wife, Meghna Khemka, at her bank account. In course of investigation, it could be learned that complainant also filed 2 other cases against her husband, Arvind Khemka, under 498A IPC, a different police station. In view of the above mentioned facts and circumstances of the case, the allegation of the complainant against her husband could not be substantiated. So this was closed, and the order of the magistrate, which is not very legible, but your ladyship will find it at page 90.
yes.
Annexure P7. Now, thereafter, your ladyship, as I mentioned at the outset, the magistrate's order is at page 89. Now, thereafter, the CWC's complaint was lodged, based on which the child's custody was given to me. Now, your ladyship will find that at page 128. Does your ladyship have it? Page 128, annexure P13.
Yes.
This is a complaint filed by the Child Welfare Committee, which is a statutory committee under the Juvenile Justice Act, your ladyship. Now, it's addressed to the officer in charge, Dibrugarh Police Station. Sir, with due respect, we would like to inform you that we have received an information regarding a child abuse case of Aditri Khemka, daughter of Arvind Khemka and Meghna Khemka, resident of so-and-so Dibrugarh, by her mother. Accordingly, we, a team of CWC members, visited Little Flowers Higher Secondary School, Dibrugarh, where the girl is studying in class 4. After interaction with the child, we found the following facts. The child is mentally tortured by the mother. so and so, who is the respondent number 2, by using unparliamentary words. Mother of the child abuses her physically by beating her with rod. The girl is suffering from pancreatitis and mother used to sit on her stomach and beat her continuously for more than 3 hours. Last year, the mother confined the child for 2 days and went to Banaras. The child attempted suicide as abated by her mother. While trying to rescue the child by Childline, the mother snatched the child and ran away without cooperating. In view of the above, the Child Welfare Committee, Dibrugarh, found it a fit case of child abuse and hence requests to register a case. Your Ladyship will find the order of the learned magistrate on 12th of May 2023, the same day. At page 133, annexure P15. IO has produced the victim X and has prayed for recording her statement under section 164 CRPC. Peruse the case record. Prayer of the IO for recording the statement under 164 CRPC. The victim X is escorted by WPC so-and-so. It also transpires from the record that the victim is aged 11 years and hence she is minor. Accordingly, I have recorded her statement under section 164 CRPC. In regard to the Zimma of the petition of the victim, the IO is directed to give Zimma of the victim to her natural legal guardian on execution of Zimmanama to his satisfaction. IO to escort the victim to her place of residence and back the case record. Now, meanwhile, she filed, all this had happened after the couple had separated. She came back to her parental home as was indicated in the first FIR. And I went back to Banaras. And meanwhile, all these developments take place and the Child Welfare Committee intervenes and custody is given to me. Thereafter, she files a habeas corpus petition. Now, an order is passed by this honorable court, a division bench of this honorable court, which your ladyship will find at page 170. From paragraph 2, the writ petition has been filed under under 226 of the Constitution of India for issuance of writ of habeas corpus to the minor daughter of the parties. For the sake of clarity, the prayer made in the writ petition is extracted herein below. I'll not read the whole of it. I'll read from para 3. This court in the aforesaid writ petition has passed an order dated 11 September 23, directing production of the child by respondent number 7, who was me in those proceedings. Pursuant to the said order, on 19 September 2023, the child was produced in an in-camera proceeding. So the judges, honorable judges, interacted with the child. The personal appearances of the parties were also dispensed with. By the IA, the petitioner applicant has prayed for an appropriate order directing the respondent number 7 to facilitate regular and uninterrupted physical and telephonic access to the minor child. The aforesaid IA has been filed in connection with WP criminal so-and-so instituted by the petitioner applicant. Sri Dubey, learned counsel for the petitioner applicant, however, submits that the present application would be pressed only for having telephonic access. We are of the opinion that since very purpose of filing an application under 226 of the Constitution of India for issuance of writ in the nature of habeas corpus has been served by production of the child, that too by her father, who is the respondent number 7, there is no scope to further entertain this writ petition. However, on consideration, the prayer made in IA, this court is of the opinion that telephonic access to the applicant mother is required, taking into consideration the welfare of the minor child, which is of paramount importance. In this regard, specific instructions have been sought for from the learned counsel, and as for the same, the applicant mother would be allowed to have telephonic access to the minor daughter twice a week, namely Tuesday and Friday between 6 p.m. and 7 p.m. However, it is made clear that there may be slight modification in the dates or timings subject to convenience of the parties. On a specific query from this court, learned counsel for the petitioner has submitted that the petitioner applicant is aware of the telephone number of the so-and-so. However, in case there is any change in such number, the same has to be intimated to the petitioner applicant so that the telephonic access which is allowed to, I'll read the next paragraph, paragraph 8. We further make it clear that the present order pertains to only telephonic access and no order has been passed on prayer for physical access. The petitioner applicant would however be at liberty to approach the appropriate forum with appropriate petition in case of any grievance. She has not approached any forum for custody. The statements made under section 164, which was the basis of this order, the statements made under 164 of the CRPC of the child in question, which were placed on record and is in custody of the registry, be returned to so-and-so, learned senior government advocate. Now, your ladyship, the child is in my custody and her exams are starting from tomorrow, and the case is also fixed for evidence tomorrow. Charges have been framed. I'll show two orders of the learned SDJM, which your ladyship will find at page 173, one order, by which bail is granted. Read from the middle, heard, perused. I have perused the record of the instant case. Upon such hearing and perusal, considering the fact that he has voluntarily appeared before this court and also considering the nature of the offense, I deem it justified to allow this prayer. Accordingly, the petition number so-and-so is hereby allowed. The accused so-and-so is allowed to go on bail by so-and-so with a suitable surety of like amount with a condition to the accused person to appear. Condition is that I have to appear on each and every date fixed and also to file an affidavit before this court, so mentioning his permanent and present address. Thereafter, your ladyship, charges were framed, which your ladyship will find at page 176, 22nd October 2024. Accused Sri so-and-so is present before the court. Today, the matter is fixed for consideration of charge. Both the sides were heard on the point of charge. Peruse the case record in light of the submissions made. Now, on perusal of the record and the case diary, the statements of the witnesses, this court is of the opinion that there are sufficient material proceed against the accused person under 498A. Hence, charge under 498A IPC is framed against the accused person in separate sheet and kept tagged in the case record. The substance of the offense are read over and explained to the accused person, to which pleaded not guilty and claimed to be tried, issue summons to the witness. The very next page, I have enclosed the examination sheet of the minor daughter who is in my custody, and the exam begin from tomorrow. Your ladyship, in the table will find the first examination is on 21st December, Saturday. Now, going back to the merits of the 482, the quashing petition, is that the initiation of all these FIRs was only to
Yes.
initiation of all these FIRs was only to wreak vengeance and to retaliate against the husband, thereby clearly attracting illustration number 7 of Bhajan Lal. If I may.
No need to.
Yes, yeah, I've extracted it in the grounds. And second, there are 2 closure reports already on similar allegations in these FIRs. So this is a pure tactic to harass. And in fact, the statements also reveal that it was only when I was invited to Natraj Hotel in Dibrugarh and there were settlement talks and the settlement talks did not materialize. Only after that, they filed the complaint against me, the FIR against me. And that too.
Yes, what is your other prayer? Any prayer? It is what?
I want stay of the proceedings, your ladyship. And of course, quashing of the complaint. That's the main prayer. And your ladyship, this is a very recent judgment. Just 10 days back, Supreme Court has pronounced a judgment on very similar facts. Allegations are very similar. And your ladyship, the proceedings.
Time of final hearing in place.
Yes, yes. But Dara Lakshmi, I'll just, if your ladyship may just permit me.
You want to proceed with it further? No, this is not a hearing stage, as a motion stage. This submission I have already.
If I've convinced
otherwise,
you,
I will. Yes,
then I don't need to.
Not it should go.
I'm praying for stay. I'll show the judgment also, your ladyship, which is right on the point. Some protection may be given because he's a single parent now, effectively.
Okay. Your good name, Mr.
A. Fukan.
A. Fukan. A. Fukan. Your name is not there, that's why I'm just saying. Your name is not here, no?
I'm not enrolled. I practice in Delhi.
Okay, okay. Are you senior any? Senior any?
No.
No. Prime Minister P. Fukan, Interim counsel for the petition, and also heard MSSH Bora, the learned additional PP, agreeing on behalf of state respondent. This is a petition, section 528 at BNSS, for quashing of the FIR charge sheet and the criminal proceeding against the present petitioner. Pending before the court of learned SDGM there, na? Learned SDGM Dibugar.
SDC within bracket S. different.
Dibugar as Dibugar. Here in PRC case number 2179 of 2022, corresponding to GR case number 2248 of 2021 and section 498 of IPC. Issue notice to the respondent through registered AD and as usual process. No formal notice is required to be served on the respondent number 1. However, extra requisite copy may be served during the course of the day. Also heard Mr. Foucault on the interim relief. It is submitted by Mr. Foucault that including the present FIR, there are 4 numbers of FIRs were already filed by the respondent number 2, only to mentally harass the present petitioner. However, at present, at present, the daughter of the petitioner and the respondent number 2 is in his custody as per order. In custody. What order was there? Your custody order was passed by?
Custody order 12th May 2023 of the learned magistrate, and that was confirmed on 8th February 2024 by this honorable court in a habeas corpus petition.
Otherwise, it was 12/5?
12/5/2023.
12/5/2023. Passed by the learned court below, which was subsequently confirmed by this court of division bench of this court by order dated
8th February 2024.
8/2/2024. 24, whereby the telephonic access aid was allowed. No?
And the physical custody was denied.
Physical custody was denied. However, the telephonic access to the present respondent was allowed with her minor daughter. He further submitted that after framing of the charge, the case was fixed by the learned trial court below on 21/12/2024, wherein he was earlier directed to appear physically before the learned trial court below each and every date to be listed. However, the examination of his minor daughter is commencing from 21/12/2024, and accordingly he prayed for stay of the further proceeding in respect of the present petitioner till the disposal of the present petition for quashing. Next, considering the entire facts and circumstances of this case, the further proceeding in respect of the present petitioner pending before the court of so and so in case number so and so be stayed till next date of listing. It will be stayed till next date of listing.
Deeply obliged. Richard, may I request if it can be made available today, the order is coming up tomorrow. It's a request.
Definitely will try. Okay, yes.
Deeply obliged.
4 weeks, 4 weeks.
May it please yours. Here, my lord, the petitioner's sons has been killed by some of the persons, my lord, and their names have been mentioned in the FIR. And my lord, on the 1st July 2022, my lord, his son was taken away by 4 videos and a forester, because that is near a forest village. And during night time, they started expecting his arrival. He did not arrive. And thereafter, the next morning, they got in for information that a dead body was found. And that was lying in the police station of Dolgao, a police, my lord. And accordingly, they went to the police station and found that the dead body of the petitioner's son. And then FIR has been lost, and that FIR, my lord, has not been accepted by the police. Then he persuaded the police, and ultimately he had to approach the SP concerned, my lord. And at the intermission of the SP, the FIR has been lost, FIR has been registered, and the investigation started. And thereafter, the petitioner could not know anything what happened to his FIR, what was the investigation stage of the investigation of the FIR. And thereafter, he came to Mongoloi court and met an advocate to see what has happened. Then on making an inquiry, it was found that a final report has been sent. And in the final report, that was a palpably matter without making any application of mine that I will show later on. Thereafter, the advocate suggested him that wait for some time, you will get the notice and you will have an opportunity for filing a Narazi petition. So accordingly, he waited for 1 year, my lord. And thereafter, also, nothing was happened. And then, my lord, being complained, my lord, he approached this honorable court either to call for a record and see what's really happened there, or, my lord, directly concern, my lord, CGM to take the final report, issue a notice to us so that we can file an application there and things can move on. The thing is pending there for a little over than 2 years.
No,
Just nothing.
Have you made an inquiry in the office of the CGM?
CGM.
What is the status of this?
It was lying. It was lying. Just
FIR
like-
was not put up before the CGM.
It was put up and it was lying.
Lying in a sense, without any order, it is lying.
Nothing, my lord. Your lordship will kindly come to see the FR, my lord. Yes, page 17. And the page 17, the FIR has been filed on 25/1/23 and 25/1/23. Now, my lord, we are ending of 24. About 2 years. Matter is pending.
25/3/24.
Yes. Now, FR has been submitted on 25/1/23. 25/1/23. So about 2 years, and 2 years matter is pending. And
Why FR was there? Due to absence of any witness evidence, or what is the ground?
And here, my lord will find, that's why, my lord, I say that total application of mine, why your lordship will kindly come to page 22. Here, my lord, I have given 5 accused persons, my lord. 5 accused persons, my lord. And so far, the 5 accused persons concerned, my lord, against 4 accused persons, they have given the FR. And against 1, my lord, nothing. Simply no mention. Page 24. Page 22. Page 22, this particular shows that one Mongol is the accused number 1. Then next page 23, name is given, it is blank, no mention. Then page 24, name is there, one Ibrahim Ali, this is also an accused, name accused. 25 is also Goni Ali is also a named accused. Then 26 is also one accused, Bilal Ali. And another person, his name is missing, even not mentioned. He is a named accused, his name is not mentioned. And I am the, my lord, person who lodged an FIR. In the evidence charge, my lord will find page, my lord, 27. 27, 4 names are mentioned in the evidence column, witness column. And in the witness column, my name is not there. I am the person who lodged an FIR. My name is not there. And the wife of the deceased is the person from whose house they have been taken. Her name is not also mentioned. We don't know anything, really. What happened to this investigation? And initially also, my lord, the FIR has been lost. That was refused. For 15 days, I roamed around. I had to approach the SP. Then at the intermission of the SP, that was registered. Then after 4 months, that FIR has been lost without informing us anyway. But subsequently also I made a search, and then I found that the FIR has been lost
It's
without
okay, but the
making me
question
a
is that-
witness even.
It is, whether it is still lying in the office of the CGM,
Yes. Yes.
it was not put up before CGM.
No. That is why, my lord, may I pray, one thing, my lord, this matter can be disposed of in a truth also. I'm asking the,
No, that's it. Call for the report, why it was
Yes.
pending, why it was pending before the
I'll-
CGM.
Yeah.
my lord,
Report is required.
my lord, I leave
The
it.
court bill.
Report from whom now?
From the court bill, Your Lordship. What is the present?
CGM, no.
CGM,
CGM Mongoldo.
Mongoldo.
Yes.
CGM, no.
Heard Mr. MS Chaudhary. Heard Mr. MS Chaudhary, the learned counsel for the petition, and also heard MSSH for us, so and so. This is an application under section 528 BNSS for quashing the. No, for quashing to know how, QDC.
We're coming against a FR report, Lordship, for questioning the FR reports.
For quashing the FR number 01 of 2023 dated 25/01/2023 in connection with Dolgaon PS case number 290/2022 under section 120B 302/34 IPC. Issue notice to the respondent. However, no formal notice is required to be served on the respondent. Next, right, it is submitted by Mr. Chaudhary that with the allegation of murder of his son, he initially approached the Dolgaon police station for registration of a case, but it was not registered, and for which he had to approach the SP concerned, and on the direction of the SP, the case was registered. But as it was no information, as no information was received from the police station, at the advice of the council, they approached the court of CGM Dorong Mongoldoi, and then only it has come to their knowledge that FR of the cases ended in FR on 25/01/2023. But till that, there is no information received from the learned CGM, nor he was served with any notice to notice for against the final report submitted in that case. Further, he submitted that it is very surprising that out of 5 numbers of the name FIR name accused, there is mention above only 4 numbers of accused persons in the FR, and in the witness column, the name of the informant of the present petitioner is also not mentioned. In a very mechanical way, the FR was submitted before the learned CGM Dorong Mongondo. In view of this, let a report be called for from the court of learned CGM Dorong Mongoldoi in regards to the status of the FR number 01 of 2023 dated 25/01/2023 filed in connection with Dolgaon PS case number 290 of 2022 under section 120B 302/34 IPC. Please the matter accordingly after 4 weeks.
After 4 weeks.
Please have after 4 weeks. We are
I-
calling for it.
Lordship through registry.
True registries. Before we call for true registry.
30.
May please your lordship. Well, this petition referred against the order of NBW issued by the learned special judge Udalguri man. Well, the case is that
The page 13 is the FIR. That a lady lost the FIR, saying that a construction work was going on near their village, my lord, and the FIR name accused person, my lord, engaged the daughter of the present informant, one of the employee. And my lord, he tried one day, my lord, he tried to commit her the sexual offense, my lord, and the offense was not committed, but it was taken, photographed in mobile, and after some days, it was viral in the mobile as WhatsApp, my lord. Hence, the case was registered against the FIR name accused person, my lord. The present petitioner is not the name accused in the FIR, and subsequently, my lord, the investigation was completed by the investigating agency and submitted charge sheet against the 3 persons, that FIR name accused person and as well as the present petitioner. And that other 2 accused persons, they were arrested and they are released on bail. And the present petitioner, my lord, page 18 is the, my lord, charge sheet here shown the absconder, my lord. Page 18 on 8. 13 first page. The present petitioner is shown as absconder in the charge sheet, my lord. And page 25, my lord, can return the first order of the learned special judge, my lord. Page 25. The case record is put up today. Investigating officer has submitted charge sheet along with case diary of this case. Registered this case as a special POX case. Issued summons to the accused number so. They are already, my lord, released on bail. And as accused so, the present petitioner shown as absconder in the charge sheet has the issue NBWA against the accused so. The very first day, my lord, without issuing any summon, the learned special judge issued the NBW and subsequent order, my lord, the same order. And next page is order is page 43, my lord. Page 43 is the last order. Here also, my lord, the same order. Repeat, my lord. And next date is fixed on 18th of January. So my humble submission, my lord, since he was not in the FIR name accused and my lord, police also did not charge him, and suddenly, my lord, charge sheet submitted against him. And learned court also, my lord, without issuing any summon, without mentioning any reason also, on the only on the basis of version of the police, my lord, belief and issue the NBWA. So the present petitioner, my lord, anyway, he is interested to participate in the trial, my lord. The honorable court kindly may, my lord, recall the warrant of arrest, my lord, and before next date, my lord, he will appear, my lord, for the ends of justice. And other accused, my lord, only his appearance, my lord, is going delay, my lord. That is my case, my lord.
Yes, Bora.
Lordship, otherwise you're showing him as absconder in the Sarse, Lordship, because during investigation, he was not found. Since he is inclining.
He
to
is saying that his name was not in the FIR.
Yes. Thereafter, Lordship, in the Sarse, his.
And very
So
first day
during
also, my lord.
investigation, something has been found against him, some material found against him, and according to Lordship, it was found and he remained untraced. Thereafter, Lordship, since he is willing to
But
face the trial, Lordship, let him give a chance.
Heard Mr. Anuddin, the learned counsel for the petitioner. And also heard MSSH Bora, the learned additional PP appearing on behalf of state respondent. This is an application of section so and so in connection with so and so. It is submitted by Mr. Uddin, the learned counsel for the petitioner, that the present petitioner is innocent and he is no way connected in the alleged offense. Further, from the FIR itself, it is seen that he is not the FIR named accused, and hence he was not aware of about the case pending against him. However, after filing of the charge sheet was filed showing the present accused petitioner as an absconder, and the learned special judge on the first date of the receipt of the charge sheet issued MBWA against him without even issuing any summon or BWA. And the date, demand date was selected. The first date was
my lord, first date-
21/9.
Yes, my lord,
21.
21/9.
And 21/9 video and thereafter in every subsequent dates the NBW was issued against him. The present petitioner is however ready and willing to contest the case by appearing before the learned special judge on each and every date if some interim protection is provided to him till his appearance before the learned trial court below, before the learned special judge. Next para, MS Ashish Bora, the learned additional PP submitted in this regard that as the petitioner is willing to appear before the learned special judge Udalguri, he may be given one chance to appear with an appropriate application for bail, which may be considered in accordance with. Next para কবি দেব এটু 18/1/2025 বলকে আছে on or before 18/5
On or before.
on or before 18/1 till then NBWA issued against so and so will be state oblique suspended. Your NBWA will be state of suspended till 18/1 you appear on or before 18.
On or before.
Your lordship. All of these, the petitioner has approached your lordship for quashing a criminal proceeding initially on the basis of a complaint. Now, my lord, if I may take your lordship to the complaint, my lord, at page 16. The case of the complainant is that, my lord, he is the owner of a plot of land. And in respect of that land, the petitioner has entered into an agreement for sale with another person on the basis of a power of attorney. That is our case. And by impersonating. If your lordship kindly sees the page 16, the complaint starts. Page 17, your lordship will find, my lord, first paragraph, that the complainant states that he, along with his mother, are the owners and possessor of a plot of land measuring 1 bigha, covered by DUG number 77 old, 1489 new, and KP Patta number new 1478. Your lordship will kindly, my lord, take note of the, my lord, these numbers of the Patta and DUG number. Now, my lord, the narration is that in respect of a part of that land, an agreement for sale has been executed by the petitioner in favor of another person on the basis of a power of attorney given by one person, my lord. Now, that person, my lord, who had given the power of attorney, my lord, that is on the basis of the Zamabandi. If I may take your lordship to page 51. That is the, my lord, copy of Zamabandi. I am trying to show, my lord, if dispute any, my lord, if there is any dispute, this is a civil dispute. And this is, my lord, abuse of the process of the court. Now, page 51, your lordship will find, this is the Jamabandi, my lord. Pattern number 1478, has your lordship got it, my lord? And DUG number 1489. That is the number, my lord, given in the complaint. Now, your lordship may kindly come to page 57. At page 57, your lordship will find the name, my lord, 49, Abidur Rahman, Jubedur Rahman. My lord, they are the owners of the land. Original, it was father's land, and the sons' names have been mutated, and they have, my lord, given the power of attorney in favor of the petitioner. So far as the complainant is concerned, his name is at page 51. My lord, serial number 51. Kamal Kishore Sen. He has already sold the land. So he is no longer the, my lord, owner of the land. So ownership is clear, my lord. He doesn't have ownership. And there are, my lord, other proceedings pending. For instance, my lord, if your lordship comes to page 66, because this complaint was lodged, my lord, on, the dates are important. Complaint was lodged on 12/5/2023, page 16, your lordship will find. 12/5/2023. Now, much earlier to that, on 19/1/19, my lord, FIR was lodged at page 66, your lordship will find. FIR was lodged by the, my lord, actual owner of the land, Abidur Rahman.
FIR.
FIR, my lord.
Is that page?
My lord?
Page?
Page 66. Page 66, your lordship will find in the first paragraph itself the DUG number and pattern number, the same numbers.
It was lost by whom?
Lost by my lord Abu Roman, who is the owner of the
Owner.
Your Lordship has seen the his name in the my lord Jamavandi. And his allegation is that my lord Kamod Kishore Sen, he had my lord encroached upon a part of the land along with her mother and allowed some other persons to stay there. So this is one proceeding, my lord, what that which has been started by this FIR in January 2019. And then, my lord, your lordship will find that, my lord, the mother of the my lord complainant, she filed a my lord suit. That was in, my lord. If your lordship kindly comes to page 79. Page 79. The suit was filed by the mother of the my lord complainant, Sobita Sen, page 79. Paragraph 2, your lordship will find the claim is in respect of that land. This is an order passed in the injunction application in the suit. Second paragraph, the petitioner's case in brief is that OP number 1 and 2 are the owners of a plot of land measuring 2 kathas so and so, Doug number 1489, Patna number 1478, the same number. And the my lord injunction was refused. The court, my lord, has discussed everything, said that he doesn't have any right, she doesn't have any right, and my lord paragraph page 81, your lordship will find that my lord the injunction was rejected. So this is a suit, my lord, pending since 2018. And there is a my lord land grabbing case that your lordship will find at page 82. That is also the order in the my lord sessions and land grabbing case. Now, my lord, all this will show that my lord, after having failed in the suit to get an injunction, and my lord, having faced these my lord criminal cases, he has filed this case, my lord, without being the owner of the land. So this is a civil dispute, and also, my lord, is a abuse of the process of the court. Now, my lord, the learned trial court has, my lord, issued initially, my lord, on the first day itself, non-bailable warrant that your lordship will find at page 49. Then, my lord, page 47 and 49, my lord. Now, the presumption has been brought that the my lord summons has been served, which is not correct on the basis of my lord the tracking the record. If your lordship comes to page 47, this is the order dated 19/7/24. Third paragraph, it reveals from the track consignment that the summons was delivered upon the accused person. So it was sent by registered post, perhaps. And my lord, it was presumed, and on the same date, my lord, a bailable warrant of arrest was issued, and on the next date, non-bailable warrant has been issued. And he has made a statement on note that he has not been served with the summons. Therefore, my
It was served only through registered post.
Yes, my lord. Because, my lord, the order itself makes it clear. Page 47, your lordship will see. Only, my lord, on the basis of the track record, it has been held that the summons has been served. Your lordship will kindly read again, my lord. The learned counsel for the complainant submitted postal receipt along with track consignment of issuing summons upon the accused person through registered post was taken. It reveals from the track consignment that the summons was delivered upon the accused person. However, accused person is absent, hence bailable warrant is issued. So this is out and out, my lord, an abuse of the process of the court, and also, my lord, if there is any dispute, my lord, that has to be settled by the my lord civil court, where the mother of the petitioner, my lord complainant, has failed to get an order of injunction, and there are other my lord land grabbing cases pending filed by the my lord actual owner. Therefore, my prayer before lordship, my lord, your lordship will stay the further proceedings, and also, my lord, recall this warrant of arrest. First thing he has to establish that the complainant has to establish that he is the owner of the land. There is no document. And the document judgment is very clear. His name is not there. It was there, he has sold the land to some other person. This is my limited
Yes,
prayer on
Warrant.
that issue.
Otherwise, also, as per order dated 1907-2022 47, notice was duly served upon the respondent number, upon the petitioner, but that day only the complainant submitted the postal receipt along with the track consignment issued to someone upon accused persons to registered post was taken. So that means that was duly served. But supervisory title suit is pending, Lordship. It will be appealed, Lordship. It is.
Your Lordship will
inclined to
examine the
appear
matter,
before
but in the
Supreme
meantime, my
Court.
lord.
Heard Mr. M.K. Chaudhary, the learned senior advocate, assisted by. You are Mr.
T Mohammed.
Huh?
T Mohammed.
T. Mohammed, the counsel for the petitioner, and also heard MSSH Bora, the learned additional PP, appearing on behalf of state respondent. This is an application on section 528 BNSS for quashing of the criminal proceeding, for quashing of the CR case number 207 of 2023, pending before the Court of Learned GMFC Kamrup and Guwahati, as well as for setting aside and quashing of the influent orders dated 19/7/2024 and 18/10/2024, whereby the bailable warrant of arrest and non-bailable warrant of arrest was issued against the present petitioner. Issue notice to the respondent, so and so, also call for the scanned copy of the LCR. Next para, Mr. Chaudhary further submitted in this regard that the complaint has been lodged against the present petitioner with some false and concocted story, wherein the respondent number 2 has no legal right over the disputed land, as it was sold by him to other person. So it was already sold, and the present petitioner executed the deed of sale at the strength of as a
Agreement for sale, my lord,
agreement for sale on the strength of the power of attorney
given by the actual owner.
Whose name is also reflected in the copy of Jamabandi. Mr. Chaudhary further submitted that earlier a case was lost by the mother of the present respondent number 2, and when he failed to obtain any injunction order in favor of the respondents, in favor of her, the present FIR has been lodged with some concocted story. However, on the actual owner was earlier lodged an FIR against the respondent and her mother on 19/1/2019, and as a counterblast, and thereafter only the present FIR was lost. The civil dispute is it is submitted that it is purely a civil dispute in nature, and the civil case is also pending, but only to harass the present petitioner has failed to obtain any injunction order. The present FIR has been lost, so and so. Further, he submitted that from the order dated 19/7/2024, it reflects that the summons were issued through registered AD, and on the basis of the track consignment report, the BWA and subsequently NBW was issued against the present petitioner, though he never received any summon, neither from the police nor through registered AD. Next part, considering the entire submission made by so and so corridor, the further proceeding in CR case number 207 of 2022 be stayed till next date of listing, and the NBWA and BWA issued against the present petitioner be recalled at present, list accordingly after 4 weeks. Next steps. Okay.
15.
Okay, your lordship.
শেষ নহ'ব চাগে।
You have come here, your lordship.
ইমান পৰা দি দিছেতো। এতিয়া I now see this one is only 14, 15 now. Start what again. There are আছে। Will not completed by even by 4 also. বেয়া কাম কৰিলো কিন্তু এটা। এনেকে দিলে দিগদাৰ হৈ যায় না চব petition দিলে চবতে everywhere they have to submit something in laws and stay now. What is this? কৰিব নালাগে না যিহেতু কমাই দিব দিছিলো সেইটো লিষ্টত প্ৰেছাৰটো কম হ'লে ভাল হ'ল they are going in fact. Yes, but
Yeah, please. Lordship, the petitioner has essentially come, your lordship, for seeking custody of certain materials, your lordship. And your lordship will kindly come to page 127. This is your lordship, the impugn order. May I read your lordship?
there are some materials.
Materials are there, your lordship, which according to them is stolen property. Search sheet is filed, initially arrested, then search sheet is filed. I am the owner of those materials. I have documents. I have annexed here. I have annexed. In fact, learned CGM has directed me to show this to the IO and take the custody. Then your lordship, the originals has already been seized. Therefore, we're waiting, your lordship. Then in the meanwhile, on page 127, learned sessions as after committal of the case has passed this order, your lordship, rejecting the custody. Now, these two order cannot stand together. Your lordship may kindly see page 127 and the ground on which rejected, that also your lordship will find perverse, your lordship. The instant proceeding, first paragraph, it is not required, first two paragraph. It is stated and submitted that petitioner is a scrap businessman having a farm in the name and style of Mr. So-and-so. It is further stated that submitted these materials were part of his business goods, which he had procured for the purpose of trading from legitimate sources, that he also pays a substantial amount of money as tax to the government. It is stated that submitted as legitimate owner, the seized material, he should be granted interim custody of same, that he undertakes to produce the same and when required by the court. I have also heard the learned public prosecutor. It may be mentioned here that case has been charged against two accused persons, namely so-and-so and so-and-so. The present accused petitioner is Mohammad Siraz Ali under provision of section 379, 411, 413. The case diary also available on record. I have perused this. The case diary reveals incriminating material against the accused person with regard to these materials. It has emerged from the statements of some witnesses that stolen properties are also forms component of the materials in scrap business of the accused petitioner. In any case, whether the accused persons have indeed received stolen property or not would be subject to trial if charges are framed against them. At this stage, question to be determined is whether these materials should be released in favor of his as sought for by him. I have also perused the search sheet submitted in the case and I find that the seized materials are indicated as relied upon the material objects in column number 12(2) of the search sheet dated so-and-so. Now being relied upon material objects indicated in the search sheet, if the same are required to be exhibited by the prosecution during the trial, the prosecution would be handicapped and prejudiced if these are released at this stage of the accused petitioner. Now your lordship may kindly come to the search sheet which I have annexed, your lordship, at page 46, your lordship. Your lordship may kindly come to 47. 46, your lordship will find 47, 12. Serial number 12. 47.
Yes.
12(1) is the particular of the witnesses. Now we are concerned with 12(2). 12(2), your lordship, particular of documents cited and relied upon.
47, yeah.
Page
Oh,
47.
yes, yeah.
12(1) is the particular of the witnesses, your lordship. Then 12(2), your lordship, we are concerned with particulars of documents cited and relied upon. Here, your lordship, these are all Caesar list, your lordship. The documents Caesar list, your lordship, sketch map, Caesar list. Then next page, your lordship will find 12(3). In fact, there is no material objects that they will rely upon during trial. 12(3). List of article material objects relied upon. It's blank, your lordship. Now the ground on which it was rejected, it's apparently perverse, your lordship. Saying that 12(2), they will rely on these material objects. That is not there, your lordship. And secondly, your lordship will kindly come to another order, your lordship. That is at page. Page 66, your lordship. Page 66, your lordship. This is by the learned CJM. 15/10/2024. This is not required first part. Second part. Later on, report has called in connection with Zimma petition number so and so received, wherein it is stated that during investigation, no relevant document regarding purchase of the seized article and trade license for operating the same could be shown. Further, it is stated in the report that the seized article are suspected to be stolen from different places for which ownership of the seized article could not be ascertained. As such, the seized article cannot be given in the Zimma of the Zimmadar at this stage. See in the report and tag it with the case record. Considering the report, the Zimma petitioner is directed to appear before the investigating officer with proper documents claiming ownership of the same, and thereafter, on being satisfied, the IO shall release the seized articles to the actual owner by observing process of so and so is disposed of. Now already there is a direction, your lordship. We will only need to show the documents. The original documents we could not show, your lordship, that those were seized by the learned court below. Now the session judge, your lordship, without considering all these aspects, passed an order.
But the 467 says otherwise also. It could not be, ownership could not be ascertained, and as such, the seized articles cannot be given Zimma to the Zimmadar
That is the
at this stage.
that
And
is,
you were directed for that for verification of the ownership or assessing. I mean the ascertainment of the your ownership
Lordship,
only.
lordship.
That was the only direction.
Lordship, that during pendency, that is subsisting, your lordship. Then the learned court below session ought not to have passed this order, waited for this to come. Because at the end of the day, there is some order saying that you go there, show the documents, and take the Zimma.
But this one is this order was prior to filing of the charge sheet, I think.
Lordship. And then what happened, your lordship, since we have the original documents, your lordship will kindly see the
We have
documents.
annexed some documents.
Page 68 onwards, everything. Tax we have paid, we have purchased it, your lordship, by paying GST legally, your lordship. Therefore, your lordship, this ordering and the ground on which this has been rejected, that is perverse, your lordship. 12.3 says that no material particulars. And this says that I have also perused the search sheet submitted in the case. I find that the seized materials are indicated as relied upon material object. That is not there, your lordship. Therefore, challenging this order, I am before this honorable court.
Yes. Yes, Boranti.
Please, otherwise, page 48, lordship. Serial number 2 from page 47, column number 2, 48, lordship. With those 6 materials objects are shown in the column number 2, lordship, otherwise.
12, column number 2.
Yes,
Their list.
yes. On the line of the serial list, lordship, that is materials are indicated above, lordship.
Yes.
In column number 12, to Roman number 2, lordship. Otherwise, that is there.
Caesar list will always reflect this, unless it
That
is not
reflected.
reflected. But 12.3 is important. List of article materials objects
These are
relied
the
upon.
Caesar list and these are the MR.
There's a brief
These are the
brief contents of the
MR numbers.
documents along with the lordship. 41 numbers of jute plates containing copper
All are
materials.
here, yes.
Those are their lordship.
Hmm.
Otherwise.
This is the content of the documents.
Yes, lordship, we called for a report that.
The contents of the document along with these MR numbers are there. That means the
Yes.
material exhibits there. These
Yes.
are all.
Yes.
That's why MR number is also there. We call for the
Scissor list 1 and scissor list white MR number 181 and 153/24. So these are their lordship, otherwise. We call for a report. State.
Report probably, your lordship, since it is before the
Now, search sheet has been submitted.
Case, now most probably investigating officer will not
Will
in a
not be
stage
able
to
to-
file any.
Okay.
We can call for the scan copy FDL, so this
Scan
TD,
copy of
TD
the-
will be there. That can be perused. I think, otherwise, we don't have any. Now, because charge sheet has already been filed, those are there in the custody of so and so, because those may be exhibited as a material exhibit, in fact. At this other stage. So call for hey corridor khali. Issue notice, no further notice is required to be served. And hey corridor, call for the scan copy of the LCR along with the case diary corridor. It is now before session judge.
Session judge.
Now before session.
Got it.
Session judge corridor.
In session case number 180 of 2000.
In sessions case number
180
180
of 2024. Pending before the session judge. Your lordship fixed.
session judge is 181.
Lordship. 180 your lordship.
180.
Page 131.
Fixing it after vacation because prior I mean
Yes.
after
Immediately on the opening, your lordship.
immediately after receiving of the LCR. List the matter immediately. It will be
After
you have to-
vacation in date, your lordship.
date will
That's why I'm not praying for your lordship before vacation. After
no vacation to nine as the last date for vacation.
First week of February.
24th, your lordship.
24. Registry will retain it to involve in the LCR.
Deeply obliged.
Obliged.
Time and I. All will be now ready. এটা মাত্ৰ খালি আধা শুনি পেলাই থৈ দিব। চব ৰ'ব আজি।
Basically, in this petition, madam, we have assigned an order framing charge, madam. The FIR, madam, is at page number 15. The allegation in the FIR is that some amount of money, that is around 2,20,000, was sanctioned for a project, and that was also released. But according to the informant, the amount of work was not that much. The amount of work was of around 73,463. So that is why
The rest
the
of the amount is misappropriated.
yes, and the FIR was lodged against two persons, Gopal Das and Mohim Bosumatari. Now, if your lordship will kindly see page number 18, the FIR against the Gopal Das, that was the junior engineer, was quashed by this Honorable High Court, madam. By this judgment at page number 18, madam. So our case is that there are no sufficient materials, madam, to frame charge under section 409 against the present applicant. Because, my lord,
He is working on what strength?
he was the then secretary of Manikpur Gaon Panchayat. So the bills that were submitted, madam, are actually verified first by the engineer, and that was countersigned by the president. And then only thereafter, the secretary released the amount. That is the actual fact, madam. And if your lordship will see the 161 statements also, the main witnesses, my lord, they have categorically stated that the actual work was completed and there was no misappropriation, madam. That will be clear once the record is called, madam. If your lordship wants to see, madam, I have the 161.
No, later on we can.
Yes, that's why, madam, I am not praying for any stay at this stage. Once the record is, madam, submitted, madam, then everything will be clear.
Cognizance has already been taken.
Cognizance taken charge frame under 409. We are against the order.
When is the
pending
next
charge.
date fixed?
Next day is the date, my lord.
Oh, yeah.
Next date will be some.
Maybe in the month of
next
January.
month or maybe. So, madam, we will only seek for a small accommodation on the next date, madam, because once the records are produced, madam, the matter can be disposed of on the next date itself.
The record is not required, madam, the LCR, madam.
Yes.
Scan copy of the LCR may be.
LCR and the 161 statements.
Along with the case diary?
Yes.
Then. Part Mr. S. does the learned counsel for the petition and also heard Mr. R.J. Borla, the learned additional PP appearing on behalf of state respondent. This is an application under section 528, so and so, so and so. And for quashing of the order dated 05/07/2024, passed by JMFC Bongaigaon, whereby the charge is framed against the present accused petitioner under section 409 of the IPC. Issue notice. State is the only party. To the respondents, no formal notice is required to be served on state respondent number 1. Also call for the scan copy of the LSI. But regarding date, you will be able to tell us. Now it's
Yes, madam, I
one,
can call for some time, madam, because by now probably a date has been fixed in the lower court.
because prior Bihu we don't have, in fact.
Yes,
It will be obviously after Bihu only.
yes. So one small accommodation for the next date, madam. We'll pay for an
Why,
advance.
Harry, for after Bihu? 29. We are fixing it on 29 one. We can request
Madam,
otherwise.
the scan copy may be called for to register.
Yes, true registry only. As they are along with the CD code, registry will do the needful. We are calling it.
One, that is not required.
Not required. In fact, it will be.
That will be a discretion of the court, madam.
Yes. Okay.
Page 21. Considering the amount of sick, dishonored and all the relevant factors, accused is hereby sentenced to pay fine of ₹3 lakhs.
Okay. That was upheld by the session.
Yes, madam.
Revision petition pass.
Lordship, my learned friend has submitted that he was in previous bail. So that order, later on, he may be submitted, Lordship. His submission may be recorded that he was in previous bail.
No,
Initially, when you someone to call, my lord, then he go to on bail, my lord. After convictions, he was not allowed to.
he is submitting that there was no
No
Conviction in
only-
person was
only
sentenced.
fine is there.
only fine is there.
Yes.
That's what he is saying.
Yes.
So, but however, he is on bail, I think.
Yes, my lord.
Yes,
He
that's
can
what
type
my,
here.
his submission may be recorded. He's on bail,
You are on bail.
Yes, my lord.
previous bail.
Item number 5, huh? Item number 5 or IA to Likibo by Mr. N. Borua. Learned counsel for the petitioner. Mr. S. Arafat, here he is appearing or what chance? No, this time his name is there in the respondents column. That's why I am just confused. And Borua, so and also heard him as S.H. Borua. It's an application under section 438(1) BNSS for suspension of sentence of realization of fine. For suspension of sentence, passed right order dated 9/07/2024 by learned session judge Sibsagar in criminal appeal number 21/2/2023, whereby the order dated whereby all judgment and order
9/7/2020. That just very important.
no 9/7 is the session judge, other one
Other one, my lord.
15/5.
Yes, my lord.
15/5/23.
Confirm the or judgment and order passed by the learned SDGM and SDGM Sibsagar in In CR case number 21 of 2021, dated 15/5/2023, convicting the present accused appellant under section 138 of DNI Act. And sentence part is already waived. Sentence part is not there. I mean,
Not there, ma'am.
imprisonment part is not there.
Not there, my lord. Only fine part is there, my lord.
Sentencing him to undergo SI for 3 months, along with a compensation of ₹3 lakhs in default. SI for another 3 months. However, by the judgment and order passed by the learned session judge, the only sentence the accused appellant is only sentenced to pay compensation of ₹3 lakhs. 3 lakhs. You are on which page you are relying on? Yes.
Actually, come to 21.
21 is order part.
Whereby lordship sentenced to pay a fine of ₹2 lakhs, lordship.
21.
21. In I, my lord.
Now very confusing. This is the order part.
Yes,
Wherein
yes. Sentence him to pay a fine of ₹2 lakhs. And in default of payment of fine, the accused will undergo SI for 3 months.
no, that is okay. Here only this is the check amount reserve so and so, but there is no any order of any alteration of charge or modification of the sentence part. And the order, in the criminal appeal, the judgment itself, it is seen that the appeal is dismissed and the judgment, the
41 page, my lord.
page number 41 is only affirmed and upheld.
Yes,
No other clarification is there.
Yes, my lord.
otherwise,
Yes. That is the confusing part.
it's very.
What to say? In the judgment itself, only confirm, I mean, the judgment of the learned trial court below is affirmed
Affirm, my lord.
only. That part, there is no clarification.
Yeah, I will apply for certificate copy, my lord. Yes,
No, it is only certified copy.
initial order, bail order, my lord. In CR case, my lord.
Okay, then we will, in
Sort
both
it.
the matters where we are issuing notice
Yes, my lord.
in the both the matters. It may be listed after vacation, you apply for, just pray less because there is nothing in fact.
Yes, my lord.
Only affirm is it's submitted stated that the trial court below order is only judgment is affirmed. That part there is no clarification at all. Whether there is any kind of modification, any kind of alteration, it's not there. Though in the order is very silent, only about the 3 lakhs compensation is there. Rest part is not
That
mentioned.
is notice may be issued, my lord.
And বৰুৱা কৰি দি দিব বাকি ইমান নালাগে issue notice কৰি দিব দুইটা matters এটা issue notice to the respondent and also call for the we are calling for the LCR also
CR, my lord.
call for the LCR ঠিক আছে দুইটাতে একে same order হবে list accordingly after due vacation we are listing both the matters after due vacation in the meantime you take steps issue notice
Yes, my
we
lord.
are calling for the LCR also rest you will do the need
এটা ভালো হবে।
70.
Well, I may be allowed to argue on behalf of Mr. M. Swiggy. I'm not going to overlook no one.
I'm sorry, Chair.
Cancel.
Otherwise, you have not filed your wakalatnama. Can it be? It cannot be.
Otherwise, it cannot be without filing.
Some adjournment prayers are made by appearing for someone that is allowed by us. But arguing the matter should not be in fact. Is there any urgency? Otherwise, we will fix it after vacation, immediately after. So whatever, what to do. Sakya is not present today.
Okay. And one week ago, he's there, my lord, but he has some difficulties. After 1 hour, he may be come.
Let us see then.
At him.
No, we cannot keep any date. We are just will go. If it reaches, then it will come again.
Develop.
Fixing it at timing.
For a
80.
May it please your lordship. An application under 528 of the BNSS 2023. Here I have challenged the order dated 29/11/2024 passed by the additional CJM Borpeta, whereby my prayer for calling a defense witness has been rejected. Lordship, before I take your lordship to the impugned order, I'd just like to state the facts. So this is a
Just
138.
first of all, you tell us whether it is a POXO related matter.
No, it's a 138 proceeding, lordship.
130.
138 proceeding, lordship. So what happened, lordship? The complaint your lordship will find, it starts from page 16. The facts of the complaint is brief facts is that the complaint states that on 6/6/2020, 2/2/2020, I took a sum of 4 lakhs as loan from the opposite party number 2 with a promise to return the same within 4 months. Since I didn't return the money within 4 months and after a lot of coaxing and he requesting me, I finally went to his house. That your lordship will find it para. I went to his house and gave him a check on 6/11/2021. The said check thereafter was presented for encashment and that was returned as due to insufficiency of funds. Thereafter, notice was issued and this application under 138 was filed before the learned additional CJM Borpeta. So the trial has proceeded thereafter. Summons were issued. I appeared. Trial proceeded. The prosecution side, the complainant side adduced evidence of 3 witnesses. Thereafter, the defense witnesses were taken up. So I adduced evidence as DW1 and another person adduced evidence as DW2. When I was adducing evidence as DW1, I took a plea that on 6/11/2021, when the check was issued, I was not in Borpeta. As stated in I was in my office in Rangapara North Railway Junction. I am working there as a train master, lordship. So I was there. So that document, one document I have produced, that document your lordship will find at Annexure 4. Annexure 4, page 27. So this document was issued to me by the superintendent of the concerned railway station. Therein it is clearly stated that I was performing duty at Rangapara on 6/11/2021. So in this regards, I filed a petition to examine the DW1 so that he can produce the register and verify the contents of that document as per section 35 of the Indian Evidence Act.
But you already adduced evidence as DW1.
Yeah, I adduced evidence, but the superintendent, I wanted to call the superintendent of the concerned railway station so that the contents of the document, because this document was issued by him, so that the contents of the document can be proved and it can be established that I was not there at Borpeta, I was at my place of work in Dorong district. So a petition was filed. That petition, your lordship will find at page 25. So this petition was filed on 19/9/2024. Subsequently, this petition was rejected by the order dated 29/11/2024. That is at page 29. So if your lordship goes to the order, your lordship will find that at paragraph 4, if I may read the paragraph 4, instant order arises out of petition number 5316 of 24 filed by Kartik Das praying to call for official witness from railway for proving exhibit D1/DW1. And thereafter it was rejected, saying that I am trying to delay the trial and it is vague. I have not mentioned anybody in my petition as to who I wanted to examine. So thereafter it was rejected by the and so I am before your lordship. The lordship knows that these applications are filed under 311 of the CRPC. At present, it will be 348 of the BNSS. So the law regarding that is pretty settled, lordship. If a witness has any bearing to do with the case and for the just decision of the case, then that witness has to be examined by the honorable court. Lordship. So therefore, I am before your Lordship. The case is now.
Now case is placed.
Yes,
at
it is
the-
fixed for final argument. It was fixed on 13/12. We have taken time on that since we preferred this. Now it is fixed on 26/12/2024.
26/12.
Yes, on Tuesday. So that is why we are before your Lordship. So if your Lordship, sir, I have a judgment, 3 paragraph.
The judgment will see later.
That is categorically stated there. And this witness is very much necessary because I have taken a categorical plea that I was not there. And the register, I cannot produce the attendance register that has to be produced by the superintendent of the railway station. So his examination will have a very positive or some kind of a bearing in the outcome of the case. So that is the reason I am before you challenging this order, Lordship.
Yes.
One 38 for proceeding state is a formal party. I have made the complainant also opposite party number.
Heard Mr. You, Mr. Chaudhary. MP Chaudhary, the counsel for the petition. And also heard Mr. MSSH Bora, the learned additional PP, appearing on behalf of state respondent. Back this is an application under section 528 BNSS. You've been ordered dated 29/11/2024, passed by learned which court?
Additional Chief Judicial Magistrate Borpeta.
Learned it's CJ Borpeta.
In NI case 138, Lordship. Oh, sorry, NI case number 196 of 2021.
In NI case number 196 of 2021, under section 138 of the NI Act, wherein the prayer of the petition filed under section 311 CRPC was rejected. Stop. Issue notice on the respondents to register AD and as usual process. No formal notice is required to be served on state respond number 1. Also called for the scanned copy of the LCM. However, considering the submission made by the learned counsel for the petitioner, the further proceeding in case number so and so, above referred case number so and so is staged till next date of listing. It will be staged till next date of listing.
Yes, sir. I'll take steps by register.
Yes, register.
Highly obliged.
Four weeks.
90.
Yes.
Petition for lots of quashing of a complaint, lots of defamation case. Lots of kindly. There are annexure 5 lots. We start from page 23. The quashing of this complaint, lots of defamation case.
Yes.
May I read this? The operative portion of page 24 Lordship, that the complainant above named Betsy state that the accused are the permanent resident aforesaid locality under the jurisdiction of the Honorable Court. On 23/6/24, the accused had a news article published through the news portal called Mongol Live, alleging that the complainant was not a member of the Coast community, but instead a member of the Lalung community. The accused also claimed that the complainant was involved in a teacher recruitment scheme and was a member of Tiva Autonomous Council. Upon finding a clip containing this controversial remark by the accused on a Mongol Live, some well-wisher of the complaint immediately sent the clip to the complainant via WhatsApp. As a result, the complaint image and the reputation in the society was tarnished, causing significant physical and mental distress. The accused person's statement was countered by the Morrigaon District Unit Akrasu, which held a press conference and facilitated the publication of the clarification in the Assamese daily newspaper Proceedings on 2/7/2024. And there are 4 posts reserved for the known Assamese individual legally residing within the Tiva Autonomous Council. As per this rule, the complainant was a member of the Tiva Autonomous Council in the mentioning that on 5/3/2020, the Commissioner and Secretary to the Government of Assam of the Social Justice and Employment Dispute appointed the complainant as a Vice Chairman, Post Judgment and Council notification number so and so. Receiving the appointment letter, the complainant did the department to join the post, but the accused locked the office.
The accused was the chairman of the Coast Responsibility Development Council last year, and taking advantage of that, the accused was able to do misdeed. The complainant tried to meet the accused several times, but the accused refused to meet him on various excuses. So the accused also held 3 executive meetings without giving any notice and invitation to the complainant. The newly appointed vice president, the complainant, and they postponed their joining a job and assuming department responsibility. Based on the statement made by the accused on the news portal on the said date and false allegation leveled against the complainant without prior notice, and the complainant appointed as the vice chairman of the Development Council has cancelled by so and so. The action taken on 5/7/2024 caused significant harm to the dignity and society, and they adversely affected his personal, professional, as well as his physical and mental well-being. It is worth mentioning that the complainant had previously served as an executive member of the Coast Responsibility Development Council nearly 11 years, 2010 to 2021. From the time of his forefather, and the complainant has belonged to the coast community. For this reason, the accused has deemed the entire coast community by alleging that the complainant belongs to the Lalung community. Furthermore, the complainant is not involved in any teacher recruitment scheme, and in addition to diminishing the complainant dignity, the incident has caused considerable harm to reputation, as well as significant damage resulting from the denial from the post of vice chairman of the Coast Responsibility Development Council of the to the complainant. Since the complainant is a resident of the locality that falls under the jurisdiction of the Honorable Court, and this case has been filed before the Honorable Court, in view of the aforesaid, the accused has committed an offence so and so is liable to punishable by so and so. It is therefore, Your Honor, please to admit this petition, register and this lawsuit. This is the complaint lawsuit. Now, lawsuit, he says lawsuit for the news published in the portal lawsuit on 23/6/2024 lawsuit. His post for vice chairman was cancelled lawsuit. Kindly note the date lawsuit 23/6/2024 lawsuit. Let us come to the page 45 now. Page 45, lawsuit annexer 1. Kindly have a look, lawsuit, the date 1/4/2024. The entire community lawsuit, after his appointment lawsuit, his appointment was on lawsuit. Kindly put 5/3 lawsuit, 5/3/24, he was appointed as vice chairman. The 5/3/2024 lawsuit. Also, can you see the page 45? Page 45, the date lawsuit 1/4/2024. Immediately after his appointment, this memorandum has been submitted to the Honorable CM of Assam lawsuit. It was, kindly have a look regarding that allegation that he doesn't belong to that community or lawsuit, and previous is some records were there lawsuit for which he was not suitable to be a vice chairman. That was the allegation made in the memorandum to the Chief Minister of Assam. Kindly have a look. Huh? No, kindly turn to page 46 now. Page 46, lawsuit, I am the chairman, the present petition. 46, lawsuit will see 2 more person, and page 47, page 47, page 48, page 49. All the members of the community of that council have signed this memorandum and forwarded to the CM model. And for this, the inquiry was held, and after finding in the inquiry, he was terminated from that post. And for that, he has approached before the Honorable High Court. Lawsuit will kindly see. Huh? He has approached Honorable High Court challenging his termination regarding the cancellation of that vice chairmanship. That on page 21, lawsuit. So this is the order that he hired M.K. Sharma, learned counsel. In the case of petitioner, he was appointed as vice chairman of the Coast Responsibility. So and so, since he was given the charge of the post, and so earlier, so and so, in which Notice was during the penitentiary impeding notification dated of the has been cancelled. Challenging this one, he approached this Honorable High Court Lordship, and thereafter, you will kindly see the government stand in their affidavit in opposition that I have annexed in the. Lordship will kindly turn to annexure 12. Page 54 is the affidavit in opposition filed by the state. That on page 55, Lordship will kindly see. Page 55, Lordship, paragraph 7. That it says, Lordship, that the deponent begs to state that on the receipt of request from the chairman and other member co-suspended relevant dated so and so department approval authority concerned and cancel the appointment, Lordship. All because the entire council has made a complaint, Lordship, so his appointment order was cancelled, Lordship. It is not that only because of his news portal bite, Lordship, he was not suspended, and that was given in 1/4/2024, much earlier than his bite. He have given bite on 26, Lordship, on 26/6. 23/6 he gave bite before the portal news, but the memorandum was forwarded on 1/4/2024. And thereafter, Lordship, he have already filed a title suit claiming the damage that I have annexed on page 31, Lordship will kindly see. Page 31, Lordship. That a page, sorry, Lordship, page 37. Page 37 is on the same ground, Lordship, that there is no bar, even the civil Lordship defamation can be at the same time simultaneously it can go on, Lordship. Even then, Lordship, the base of the same allegation, he have filed a title suit claiming the damage for his reputation, Lordship, page 37. And Lordship, this is the factual part, Lordship, where Lordship it is completely denied, Lordship, that I am not the sole person responsible for it. Entire council, Lordship, there is a factual part. And regarding the procedure part, Lordship, may I come to page 33, Lordship, Annexure 7. Annexure 7, Lordship, page 33.
It's a cognizance order.
Cognizance. Lordship, as per the new BNS, Lordship, that Lordship directly without hearing the Lordship accused person, that cognizance, Lordship, part cannot be taken up. And moreover, Lordship, the case has been registered in IPC, Lordship. It was filed, Lordship, in the month of July. So, Lordship, BNSS should be, Lordship, followed. And that it clearly says in the order, Lordship, that it is concurrence took place on 23/6/2024. Hence, the provision of IPC and CRPC would be applicable in the case, Lordship. That is the procedural lapse in the part of the Planet Court below, Lordship, issuing the summon. That on 223, Lordship. And that has been clearly, Lordship, mentioned in the Honorable Division Bench, Lordship, by this Honorable Court, Lordship.
It's okay, but your petition, your complaint was filed on which date?
On 15/7, Lordship.
Complaint was of 15/7?
Lordship.
7.
15/7 complaint was passed and the order was passed on 19/7. Lordship. It is clearly said it is in the concurrence took place on 23/6/24 and hence the provision of IPC and CRPC will be applicable in this case. Accordingly, so and so allowed.
Yes, they see the date of occurrence is on prior to amendment, I mean, prior to new IPC.
Starting, I think 23.
No, 15-7, আগৰ order, page 32, sir.
Page 24 the applicant.
সেইখনটো বেলেগ, page 8খন চাওঁ।
Complaint case starts on 2306.
There is no dispute regarding that part. Regarding the CRPC part is this, the procedural lapse. It should be BNSS lordship, as per the division bench order and as per the
It's saying
section lordship
Filing should be
223.
under BNSS. Occurrence under IPC, filing should be under BNSS.
Otherwise,
That is his.
have cause of action to be.
এইখন চাম না। মানে IPC টো ল'ব পাৰে কিন্তু প্ৰচিডিউৰটো আপোনাৰ BNSS হ'ব। And moreover, lordship, that the as per the new act, lordship, that without hearing the accused, lordship, the cognizance cannot be taken. No?
This context, review the investigation registration of cases with regard to the date of occurrence of the offense, date of registration of crime, 1/7/2003. I want to get cause of action 23.
টো কাৰণে তো IPC টো ল'ব, কিন্তু জুলাইত ফাইল হোৱাৰ কাৰণে BNSS প্ৰচিডিউৰ হ'ব। ফাইলটো কেতিয়া ৰেডি নকৰে? ফাইলটো জুলাইত হৈছেতো, সেইকাৰণে BNSS ৰেডি হ'ব। অকাৰেঞ্চটো IPC টো ঠিকে আছে, আপোনাৰ প্ৰচিডিউৰটো আপোনাৰ BNSS ফলো।
But notice should be at the state.
Stay lordship, I'm independent lordship. That is my both the part lordship, that is factual part and the procedural lectures are there.
Heard Mr. S. Puneet, learned counsel for the petition. And also heard MSS, the learned additional APM on behalf of state respondent. This is an application under section 528 of BNSS for quashing the imputed proceeding of CR case number 599 of 2024 under section 499 of the 500 IPC pending in the court of learned CGM Morigaon, as well as the impugned cognizance order dated 19/07/2024. To issue notice on the respondents to registered AD, and as usual process, however, no formal notice is required to be served on the response state response number 1. Also call for the scanned copy of the LCR. Expired submitted by Mr. Munir that there is error in both that there is the petition by this petition, they have challenged both the factual part of this case as well as the legal procedure. He submitted that the alleged right was given only on 23/06/2024, but much prior to that, one representation was made before Honorable CGM, CM, for cancellation of the appointment of the respondent number 2, as he is not a person from post Rajbangshi community. On the basis of which his appointment was also cancelled by the government on 5/7/2024. If further submitted, then I did that the further he submitted that the cognizance which was taken by the learned trial board below is also not as per proper procedure, and the cognizance and the cognizance was taken without hearing the accused petitioner, which is required as per the provision of BNSS. Accordingly, he paid for stay of the further proceeding in case number so and so so and so. Next paragraph, considering the prayer made by the learned counsel for the petitioner, they the further proceeding in respect of the present petitioner. Only one sole accused is there. There are other accused.
No,
paper, and these are not the accused.
No.
The paper publication was also there.
No, but he has not made,
See the complaint.
no, only me, Lord.
In a complaint case against you only.
No, Lord.
Be state in case number so and so pending before the learned so and so. List accordingly after 4 weeks.
State, Lord. Lord. Much obliged, Lord. Much obliged. Lord.
20.
Application under section 428. I'm challenging the order dated 5/8/2024, as well as the continuation of the proceeding in the NI case. My lord. Factually, my lord, the present petitioners are the petitioner number 1 is the, my lord, Carta of a HUF, and the petitioner number 2 is the signatory of the said fund. And they own a, my lord, tea garden along with a factory. There is an agreement with the respondent for certain transaction. Then ultimately, in pursuance of a check that was issued by 2 of the signatories, the complaint under section 138 has been filed, and the learned trial court has, my lord, straightway, my lord, issued process, my lord, at page 23. Lordship may come to page 24. I'm challenging this order on 2 grounds, my lord. Firstly, my lord, is total non-application of mine, and secondly, my lord, in violation of section 223 as well as section 225. My lord, both the petitioners as well as the other accused also are, my lord, residing outside the jurisdiction of the court at Dibrugarh. So therefore, my lord, the examination or the inquiry under section 225, which were earlier 202, is, my lord, imperative. And secondly, under section 223, as, my lord, in the earlier case, my lord, the change has been made in the new, my lord, the BNSS, my lord, that accused has to be heard. So that has not been there. Neither any of the witnesses that, my lord, those have been, my lord, examined by the learned trial court. And the cognizance has been taken.
Cognizance has been taken only on the basis of statement of the complainant.
No witnesses have been, my lord, examined, nor, my lord, any opportunity was granted to the accused before, my lord, of hearing before the, my lord, cognizance has been taken. Is at page 24, my lord. It clearly reflects, my lord, that the non-application of mine, my lord. Complainant Indrajit Singh is present today. I heard him on the issue of limitation, meticulously perused the case record along with the original exhibits. Upon perusal, it is found that the case is within the parameters and stipulated time period laid down in NI Act. Cognizance is accordingly taken against accused Jayan Sharma, Rana Ranjit Sharma, he is the petitioner number 1, Ritesh Sharma and Shekhar Sharma, this petitioner number 2 under section 138 Act. And then, madam, it should be, madam, the summons. So it's a complete aberration of the procedure, madam. The right to be heard before, madam, the cognizance is taken has been violated. So I pray that the notice may be issued and the further proceeding may be stayed.
Has state is a party formal or no? No, it's okay. You have not made party state as a formal.
No, it's a private.
No, it's okay. I'm just asking.
No.
20, yeah. Heard Mr. PJ Cheque, the learned senior advocate, assisted by
RS Mr.
RS Mishra. For the petitioner. This is an application under section 528 BNSS for setting aside and washing of, for washing of
Order dated 5/8/24,
criminal
as well as the continuation of the procedure.
proceeding is number NI
NI number 138,
Acha.
2024.
proceeding, criminal proceeding in of NI case number 138, packet C of 2024. Where it is pending?
Pending in the court of
JMFC.
JMFC.
JMFC Dibrugarh. And also challenge the order of taking cognizance dated 05/08/2024. 24 postal. Issue notice to the respondents. also call for a scanned copy of the LCM. Heard Mr. Sakia, the learned senior advocate on the interim prayer. It is submitted by Mr. Sakia that the cognizance order itself is illegal and the cognizance has been taken without any application of mind. If further submitted, who is out of station? But I mean, both the petitioners.
Both the petitions.
Both the petitioners are
Residing outside the jurisdiction of the court.
residing outside the jurisdiction of the learned court below, and hence without complying the provision of 225 BNSS, the cognizance has been taken, and in the same time, as per the BNSS under section 223 of this under section 223, the cognizance cannot be taken without even hearing the accused side. Accordingly, it is submitted that till the disposal of the present petition, the further proceeding in respect of the present two petitioners may be stayed. Next paragraph, considering the submission made by learned counsel Mr. Sakia, the further proceeding in respect of present two petitioners be stayed till next date of listing. List accordingly after 4 weeks. You take steps, we are staying it.
Obliged.
21.
May I plead?
Yes.
My lord, in this case, by the impugn order, my prayer for further cross-examination of the witnesses were rejected now. By the further cross-examination of the prosecution witnesses were rejected, my lord. My lord, you may come to my petition, my lord, that is at page 33, my lord. May I read, my lord? That the accused Sri so-and-so was forwarded before this honorable court on 10/4/24, and on the same day he was sent to jail hazard, and subsequently thereto he was never produced physically before this honorable court. That the report reveals that on 27/6/24, charge under section 6 of POCSO Act was framed, but even on that day also he was not produced physically. All the witnesses were examined in absence of the accused, and even the examination under section 313 CRPC was recorded on 29/10/2024 while he was in judicial custody at Tinsukia jail. The report reveals that the statement under section 313 CRPC is shown to have been recorded on 29/10/24. However, the signature of the accused is allegedly taken on 30/10/24 at Tinsukia jail, which is countersigned by the jailer. That the report further reveals that altogether 4 legal aid counsel at different point of time represented the accused, and as per record, the cross-examination of the witnesses have been carried out by learned advocate so-and-so. Then that on 3/12/24, the relatives of the accused handed over the brief of the case to the present advocate who visited the Tinsukia jail to take instruction from the accused, and during interaction with the accused in the jail hazard, it is found that he can speak only in Nepali language, and even he cannot speak clearly and properly, and he is in jail. He is aged about 78 years. During interaction, the present advocate took assistance upon convict, namely so-and-so, who is aware of Nepali language and conversant met with accused so-and-so. That during interaction, it is found that earlier advocates failed to bring the actual facts of this case. During cross-examination, the true description of the PO is not brought on record. There was a village meeting on the concocted allegation of the complainant, herein held on 9/5/24, and in the said meeting more than 25 persons assembled, and in their presence the complainant, her family members demanded rupees 2 lakh and 1 bigha of land from the accused, and threatened that in failure thereof they will lose one case. When the accused failed to concede to the said demand, then on the next day the instant case was lost. The accused, then my lord, all these things are made, and ultimately, my lord, the prayer is made for de novo trial as well as for re-cross-examination of the witnesses, my lord. This prayer was rejected, my lord. The impugn order is at page 36, my lord. Page 36 is the impugn order, my lord. I'm reading from the last paragraph, my lord, the court finding, my lord. This court has carefully gone through the case record. It is revealed from the record that the trial of this case is duly conducted by engaged defense counsel. It is also revealed that on each and every date the accused is produced before the court through VC situated. So the facts mentioned in the petition are not found to be tenable. When the accused is duly represented by his counsel, there is no question of the accused being prejudiced. Learned advocate so and so has submitted in the open court to reject this petition. This case is pending at the stage of defense witness. Learned advocate so and so is defending the accused. At this stage end of the trial, this court does not find any plausible reason to start de novo trial. This will frustrate the very purpose of justice, hence this petition stands rejected. My lord, I am not seeking for any de novo trial, my lord. My only prayer is for further cross-examination of the witnesses. My lord, what happened in this case, my lord? This person is aged about 71 years, my lord. He is in jail all along, my lord, and he was produced through the VC, my lord. Even if lordship may kindly see, my lord, 313 statement, my lord. That is at page 25, my lord. My lord, this was recorded through VC, and lordship may find, my lord, page 25, my lord. My lord, in the first paragraph, my lord, this was recorded on 29th day of October 2024. Date is mentioned, my lord, in the, and my lord, lordship may kindly see in the, my lord, left side, my lord. This was signed by the accused, and then, my lord, it is countersigned by the jailer on 30/10/2024. In the bottom side, my lord, there is sign, and then, my lord, countersigned by the jailer. So this accused is not able to understand what is going on in the court. My lord, only when the new advocate was engaged, he come to know all this. So my only prayer with regard to recross-examination, my lord, one similar petition was moved yesterday before the coordinate bench, my lord. And this court has disposed of this criminal petition.
Yes, Bora.
But a similar issue was there also, my lord, and this honorable court disposed of the criminal petition by directing for the court to call the witnesses only for recross-examination, not for any other thing.
My lord, this application has been filed, my lord, in total malafide intention, my lord. And my lord, it's a clear abuse of the process of court, my lord. Why I'm saying, my lord, entire my lord prosecution witnesses have been examined, my lord. After that, my lord, critical statement has been recorded. Then it was case fixed for my lord defense evidence, my lord. Now, my lord, this application has been, my lord, filed, my lord, which was rejected by the trial court, my lord, with a prayer to my lord, de novo trial, de novo trial, what, my lord? The entire, my lord, evidence, entire trial will start from FS, my lord. After my lord, framing of charge, my lord. That means, my lord, from the PW1, my lord, they will examine the PW1, then they will again cross-examine, my lord. My lord, happen, can it be allowed, my lord, at this stage, my lord? It's a case of POXO, my lord. Now, my lord, the accused person, he is in jail, my lord. If he is not produced in the court, my lord, that is not the duty of the court, my lord, that he should, my lord, he should be present in every stage of the trial, my lord. It is also duty of the, my lord, counsel for the defense, my lord, to make him produce, make him appear or make him present in the court at the time of, my lord, examining the or cross-examining the witnesses, my lord. Now, my lord, when the
But the question is that that was not done.
That was
And
not done. But
from here it is seen that why the jailer had to put his counter signature in this way. That means he was not produced at the time of even recording the T13. That is there.
Then, my lord, but how he can be, my lord, prejudiced, my lord? So the question is that whether he is prejudiced, my lord. And lordship may kindly see, my lord. Kindly see his 313 statement, my lord. He has not said any explanation, my lord. He has just denied, my lord. Lordship may kindly peruse, my lord, 313 statement, my lord.
It's not true only. Everywhere it is not true.
Not true, my lord. Only, my lord, when it was asked, my lord, whether, my lord, will you adduce any defense evidence, he said yes. My lord, question is that, my lord, that accused has to be prejudiced, my lord. Then only, my lord, this application can be filed, my lord. And what is the prayer, my lord, in this petition, my lord, to stay the proceeding, my lord?
Stay cannot.
That cannot be, my lord. Yes, there is an interim prayer, my lord, to stay the proceeding, my lord.
My lord,
but simple question is that he, as per the submission from Mr. Gupta, he is a person from that people, our community, Nepali community, and he could not, he cannot understand other languages. That may be one of the aspect. And then, if he at all the occasion, if he produced through VC only, I don't know how far the advocate concerned had any talk with him, or whether any proper defense was taken. These are maybe one of the aspects.
These are maybe, my question is that, my lord, whether if this application is allowed, my lord, whether the entire prosecution can be cross-examined, my lord.
That cannot be.
That cannot be, my lord. The question is that my lord, he has to be prejudiced, my lord. If the defense counsel has not taken any steps, my lord, or he was not produced before the court at the time of trial, my lord, or at the time of cross-examination, or suppose, my lord, he has not given any, my lord, advice or legal counsel, my lord, with the, my lord, defense counsel, my lord, that it may be a, my lord, case of prejudice, my lord. Nothing, my lord.
Okay,
My
yes,
lord,
sir. Information.
I have annexed some of the orders, my lord. It says, my lord, on the even on the date of the examination of witnesses in 313, he was produced through the VC. And my lord, I do not know the factual position. What they have told me that when it is VC, my lord, they made a phone call, and through the phone call they used to interact with the person. My lord. I'm not personally do not know what is the situation, but these are, and my lord, I have
But
the,
actually during the COVID pandemic, there was a situation when the accused persons could not be produced
Yes.
physically
Yes.
before.
Well, my
But
lord,
thereafter it was over, I think.
over,
Why?
and my lord, even the POCSO Act, my lord, section 36 says, my lord, child to not to see accused at the time of testifying, but it says, my lord, at the same time, the accused in a position to hear the statement of the child and communicate with his advocate. My lord, the accused is in jail, advocate is in court. And my lord, I have made the statement in the petition that all these earlier advocates were given by the DLSA. They have never met this person, my lord. So they do not know what is the facts, my lord. And my lord, 311
Your next date is fixed on when?
on 24/12 for my lord, for production of defense evidence, that is at page 37, 24/12. And my lord, the order I have given is similar case, my lord, if lordship may take up the order, my lord.
Okay, order is okay.
My lord, in that case, my lord, the coordinate bench had, my lord, set aside the order by directing the trial court to call the witness only for further cross-examination. I'm not saying for any de novo trial or anything, not my lord. Only for further cross-examination of the witnesses. That much is clear.
Have you produced all the evidence of the PWs here?
Yes, my lord, I have annexed all that.
Here,
Yes, my lord, I have annexed. My lord, lordship may page 10. It starts from page 10, my lord.
page 10.
10.
So you have annexed all.
Yes, my lord. I have annexed all the, my lord, PWs and, my lord, the orders when that these witnesses were examined and 313 statement recorded. The accused was produced through VC. If lordship may want to see the order, my lord, page 29, my lord.
Okay, then we'll fix the matter on. It is the case is from which district?
Tinsukia, my lord.
Tinsukia. Please board back. There scan copy we are calling the, but stay cannot be there.
Next question is that, my lord, it's a POCSO case, my lord, first notice has to go, my lord. It's a POCSO case, my lord.
Perhaps that notice is for bail and all this. I'm not on this, my lord. I'm on the not on the merit, my
Question is,
lord.
my lord, in my lord, the decision then judgment, my lord. The victim is to hear, my lord, on every stage of the case, my lord. So this is our also, my lord, one stage of the case, my lord.
It's
Although
not
trial
that
has
only
not
bail,
concluded.
every stage, especially in POCSO, it has to be. Do one thing, refer an adjournment on the next day, and we issue notice to the respondent number 2. In the meantime, we are also calling for the scan copy. I cannot say it will be immediately after vacation, but after BU vacation, it may be fixed.
My lord,
20.
that I leave to
20 or 21.
But then I pray, my lord, stay, because if, my lord, my prayer was not the trial court reject, then, my lord, the argument will
No,
be
you
that
are yet to cross over two stages. That means
Defense-
one is of defense witness and then the argument.
my lord.
So it's not the case that you're going to, your matter will be going to hear by the
Lordship
argument.
may observe that, my lord, on the next date, if it will be not disposed of, then my interim prayer will be considered. That much observation.
That,
no,
that
no,
consideration I never accepted.
Because, my lord, if it is not taken up, then, my lord, this petition will be infructuous, my lord.
No.
Because service and all this.
Take steps. এটু খালি হেৰি কৰি দিব Mr. Hard Mr. A.K. Gupta, this one also. Issue notice এটা কৰি দিব for respond number 2 through jurisdictional police station routed to the office of the registry and public prosecutor. And also call for the scanned copy of the LCR. This day matter, do you have any idea? Next date is on 24th. 24/12.
But POCSO date, they generally court gives the date about 15 days the duration. ma'am.
কিবা কি ক'ব
Let it be 9 or 10, my lord.
মানে এনেকুৱা অৱস্থা হৈছে we are facing such kind of situation, you know. Every one is seeking for time. We don't have any dates, in fact. What to say?
Can it be 9 or 10, my lord?
Then now নিদিব then বহুত দিছে 9 wood. Oh, people. What problem will be 7? Then it can be. We're facing very much problem, for giving dates, and everyone is seeking for dates. So yeah, we don't have any. 7. Okay, 7. We're listing it. 7.
This my lord, this much of the, if it is not disposed of, then my lord may interfere.
My lord, it is for defense evidence, my lord, they can very well take time, take
Yes,
time.
they can.
My lord, what a POCSO case, my lord, I'm not seeking to delay the matter, my lord.
The application will be filed, my lord.
It will be delayed only.
Yes, my lord.
It is only filed to, my lord, delay the process.
No, my lord, no, my lord, not to delay the matter, my lord. All right.
My lord, I may be allowed to appear on behalf of the Zakaria man. Is my colleague. I may be allowed to appear on behalf of Learned Counsel, Mr. D. Zakaria man.
No, in one occasion, we have refused. We cannot allow. Do you have any Wakalatnama? Wakalatnama you have?
No, my lord.
Then we're timing. In one occasion, we already rejected the prayer. 22. Will it be timing? We are saying. If he comes,
My lord, no, today, my lord, he is not there, my lord.
huh?
He is not present, my lord.
He's not
He is
here.
not present, my lord. But please.
Oh, I thought he is here. Then after vacation. List after vacation.
23.
May I please, ma'am? My lord, this criminal petition is filed for quashing of the FIR, my lord. My lord, the FIR it starts from page 15, my lord. My lord, this is a long FIR. It relevant will be from page 17. My lord, the allegation is that, my lord. My lord, the allegation is that, my lord, this petitioner, these two petitioners, they got some contract, and for doing that work, they have took some money from the informant, my lord, but they have not returned the money. That is the allegation, my lord. My lord, I'm not reading the entire FIR, my lord. This is a long FIR. Lordship may kindly see page 20, my lord, 20, my lord. It starts from page 17. And then it Lordship may directly come to 20, my lord.
Yes.
My lord, in the bottom part, my lord, after receiving, my lord, received and entered in GD by number so-and-so dated 30/11/24 and prima facie reveals that the fact has commercial dispute in nature and hence entrusted inquiry to so-and-so and report within 15 days. My lord, the police initially after receiving, they themselves written that this is a commercial dispute, my lord, and Lordship may kindly come to page 22, my lord. This is the inquiry report submitted, my lord. May I read, my lord? With reference to the subject cited above, I have the honor to state you that on 30/11/24, one Sri Sawanmal Agarwal, son of so-and-so, resident of so-and-so district in Sukia, Assam, submitted a written petition to this PS stating that on 19/12/21, Sri Vijay Agarwal, son of so-and-so, proprietor of Vijay Agarwal and Sons, resident of so-and-so, Tinsukia, Assam, along with Saurabh Agarwal, so-and-so, Tinsukia, visited his shop situated at Siding Bazaar and told him that he has been allotted with the preliminary work order issued by the District Mission Director, JMM cum Executive Engineer, PHE, Dibrugarh Division of Jal Jeevan Mission, and asked him to provide financial assistance for financial support to him to implement and execute the work, and also assured that Saurabh Agarwal will look after the entire work with a promise to return back the amount by 31/3/23. Accordingly, the complainant provided financial assistance total amount of rupees 3 something to Vijay Agarwal and Saurabh Agarwal from 27/12/21 till the month of August 2022 by making bank transfer in their names. But the accused persons failed to return the amount to the complainant, and when the complainant asked about the money, then the accused persons became furious and started abusing him and refused to return his money. Accordingly, inquiry was entrusted to me by GD number so-and-so dated, and based on inquiry, a prima facie under section 406/420 IPC is found exist into the FIR. Hence, I request you to register a case for taking further legal action.
This, from the inquiry report, it reveals as well as the allegation in the FIR, my lord, this is out and out a civil dispute, my lord. Instead of filing a suit for recovery of money, they have filed this criminal case, my lord. And my lord, there are judgments, my lord, which says that, my lord, in case of civil dispute, my lord, criminal proceeding is not maintainable, and therefore the FIR can be quashed, my lord. And
Well, at this stage, my lord, notice may be issued, my lord, and my lord, case diary may be called for, my lord.
Still in the investigation stage.
investigation stage, my lord.
Oh,
And my lord, I pray for in further, my lord, that investigation may be a stage because this is a civil.
investigation stage.
That cannot be, my lord.
At least, my
There is
lord,
Supreme Court judgment, my lord, regarding investigation.
no,
Investigation
my
cannot.
lord, it is not absolute bar, my lord. Perhaps my senior friend is saying about Niharika infrastructure. Supreme Court says, my lord, in appropriate cases, if the court finds that no, there is nothing for a criminal
Now,
proceeding.
see, you have saying that this is a civil dispute. Yes, maybe there may be some reasons because the agreement was there for the purpose you got finance, but financial assistance was from the company petition. I mean, complainant side. But the question is that you promised to refund the money and then you did not refund. There may be a civil dispute, but the question is outrightly, if you prima facie see, there may be a case also under section 420 or something, maybe otherwise. So it's not a case that outrightly you cannot say that there's no criminal, obligations are there also. So in that case, investigation is still going. Are you on bail?
No, my lord, they have not filed any bail, my lord.
Bail application you have done.
Lord, at least no coercive actions shall be taken
That
against
cannot
them.
be, my lord.
That cannot be.
My lord, Lord,
You
you
file
file
it-
Perus, my lord, page number 22, my lord, last two lines, my lord.
Yes.
There is a on the inquiry report, my lord. Accordingly, inquiry was entrusted to me by within entry number so and so, dated so and so, and based on inquiry, a prima facie under section 406, 420 IPC is found exists into the affair. Hence, I request you to register a case for taking further legal action.
Now, earlier when the FIR was there, the GD entry was there, and they thought there is a commercial dispute, maybe a commercial
lord.
dispute. So accordingly, inquiry was conducted by someone, entrusted to someone. In the inquiry only, it has come to the prime facie, there may be a
Details are
case.
there. So,
In the long run, there may not be also, I don't know.
at least as my lord, FIR, my lord, case diary may be called for, notice may be issued, my lord. If after perusing the case, the lordship finds a my lord, it's a my lord, commercial dispute
Or till then,
civil
suppose if it is no materials has been collected by
then
the so
some
far, then
order may be passed.
it will be required to issue notice on the other 2-3 respondents also. May not be required also. If I have made party, because case is still.
After the investigation is entrusted to the IO, my lord, what happened? He has, I have annexed the notices, my lord. He has given the phone call to these persons and asked them to come to the police station and settle the matter, my lord. These are the allegations made. I am alleging malafide on them. That's why I have made the party.
Now this opposite party number, respond number 2 is, who is he?
Two is the informant, my lord. And
Okay, 2 is the informant, 3 is the
three is the, my lord, he is the
officer in charge.
and 4 is the IO, my lord.
He has been named mine, he has been
You are-
party by name, my lord.
Oh, you
So,
cannot
my
get
lord, then my lord, notice has to be issued,
Notice
my lord.
notice as to, you have made party by name, na?
by name, because I am alleging malafide.
Part করে দিব এটা হেরি হওয়া না চার্জশিট হওয়া না হ্যাঁ for quashing of the FIR in connection with Tinsukia PS case number 440 of 2024 corresponding to GR case number 915 of 2024 under section 406 420 IPC. Simple করো সময় নাই issue notice করে দিব to all the respondents to register reading and as usual process. No formal notice is required to be served on state response number 1. Also call for the CD. For CD, you need a date, I think.
My lord. After vacation, my lord.
When it can be fixed.
My lord, 21 or 22.
21?
21
21.
January.
We're fixing it on 21 January. Let
Okay.
us see whether what materials they have collected so far by the eye.
Okay.
24.
May be Lordship. This is the quashing petition, Lordship, of the proceeding of DB proceeding, Lordship.
I am challenging the entire proceeding as because, Lordship, there are some omnibus statements made, allegations made against the entire family of the petitioner, Lordship. The petitioners are related, Lordship. Petitioner number 1 is husband, and petitioner number 2 is sister-in-law, 3 is mother-in-law, and moreover, Lordship, the 4, 5, 6 are from a different family. My paternal uncle of petitioner number 1, paternal aunt, and the daughter of my paternal uncle, Lordship. So they are completely a different family, Lordship. They were also implicated in the allegation, Lordship. Lordship will find that we have received notice and the petition is annexed as annexure 1, Lord. Page 15. Yes, page 15 and 16, Lordship. The allegations, page 16. Lordship will find para 3 that on last 25/11/2022, registered marriage between the aggrieved and OP number 1 took place at Kamakhya temple. At the time of marriage, the parents of the aggrieved gave sufficient sridhan like gold ornaments, wooden furniture, utensils, and clothes, etc. The aggrieved, along with the sridhan, started her conjugal life at the residence of her matrimonial house. That soon after the marriage, the opposite party started insulting the aggrieved, stating the sridhan to be of low quality. That the opposite party started mental and physical torture upon the aggrieved with or without any reasons. The aggrieved used to come home at late night after taking alcohol. However, whenever the aggrieved raised objection against the same, the opposite party jointly tortured her. The opposite parties always harassed her to her foodings and clothings. So these are, Lordship, omnibus statements just to harass the entire family of the petitioner, Lordship. There is no, Lordship, exact allegation that this person has committed this offense and this domestic violence was committed by the petitioner number 1 or these are common statements, Lordship will find. And again, she is saying, as the parents of the aggrieved were poor, she continued her matrimonial life by tolerating all such tortures. In the meantime, the aggrieved became pregnant. During her pregnancy, if her husband brought any food items for her, her mother-in-law and sister-in-law did not allow her to eat the same. In another way, allegation is that husband is torturing her, and in another statement, she is saying that when husband brings some food for her, Lordship. So these are contradictory statements, Lordship. The opposite parties always harassed her in her foodings. The aggrieved was required to be abused and even assaulted if she ate anything on her own. That on last July 2023, the husband of the aggrieved coming from Lolbom festival asked for rice at 4:15 AM, but as some delay was caused in serving the rice, she kicked at her abdomen. As a result, bleeding was started. The opposite parties admitted the aggrieved at Kalicharan Hospital, Virubari. The aggrieved gave birth of 6 months old twin children at the same hospital. However, one was born alive, but another was born dead. The child born alive died subsequently. The aggrieved went to her matrimonial house from the hospital. She remained ill for a month at her matrimonial house. So these are the statements, Lordship. In fact, the 2 child were premature babies were born, Lordship. One was alive, and that child was also subsequently died, Lordship. It is not a case of any harassment or allegation. These are all allegations, Lordship. And moreover, Lordship, on the point of law point that if the persons are not from a joint family, Lordship, the DB Act cannot be filed against them, Lordship. So I am relying on judgment. So at this stage, Lordship, my prayer before your Lordship and follow in this case, own sister-in-law, they were residing in another district, Lordship. The proceeding was later on quashed, Lordship. In this para 12, 13, and 24, your Lordship will find. So at this stage, I am praying before your Lordship to give a chance to the petitioners to settle the matter, your Lordship. In fact, there was no dispute, only because, Lordship, she lost her child, Lordship. Now maybe she has taken this stand, Lordship. Otherwise, Lordship, petitioner number 1, he has also lost his child, Lordship. So at this stage, your Lordship may issue notice and further proceeding may kindly be stayed
giving some time to the petitioners to settle.
It's a
the
DV case. How
Lordship.
can we stay?
DB Act Lordship, some protection till the next date, your Lordship. As because there is a law point also involved that Lordship, if the member is not from a joint family, Lordship, DB Act proceeding cannot be initiated. So my humble prayer before your Lordship to issue notice at this stage. And further proceeding may kindly be stayed, Lordship, till her appearance, Lordship.
But now she is not staying with you.
No, Lordship. After the birth of the child, she went to her home for parental care, Lordship. There was no dispute in between us, Lordship. After returning to her own house, Lordship, that she is now filing these cases, Lordship.
Yes, you're a formal party, I think.
Formal party, Lordship.
Ms. R. Chaudhary, the learned counsel for the petition. Also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section 528 BNSS of washing the DV case number 65 of 2024 under section 12 of the PWDB Act, which is pending before learned GMFC. Nullby. Issue notice to the respondents. No formal notice is required to be served on the respond number 1. Also call for the scanned copy of the LCA. Next, para MS Chaudhary, the learned counsel for the petitioner, further submitted that there was no dispute between the parties, but after loss of two twin children, premature children, the dispute started, and out of frustration and all, she might have lost the case against the present petitioners. More so, the petitioner number 4, 5, and 6 belong to other family, and they are not the resident of the same house. They are not the
Within the definition of joint family.
they are not the residents of same house and not and doesn't fall within the definition of joint family. However, further she submitted that apart from the that there is no any other dispute between the parties, and probability of compromise is also there. And accordingly, she submitted that one more chance may be given to the parties to settle the matter amicably. Accordingly, she submitted that till next date of listing, the further proceeding in connection with DV case number so and so may be stayed first. Considering the submission made by learned counsel for the petitioner, and also considering the fact that there may be a talk of compromise between the parties, let the further proceeding in DV case number so and so be stayed till next date of listing. List accordingly after 4 weeks.
No, I'm deeply offended. 25 also same, Lordship, quashing of the DV proceeding. Here, Lordship, the petitioner number 1 is a government employee, Lordship. Moreover, Lordship, the petitioner number 4, page 3, your Lordship will find petition number 4. She is the sister-in-law. In fact, Lordship, in this case, she has not seen the aggrieved person till date, Lordship. She is a resident of the state of Bihar, circle officer appointing, she was appointed there, Lordship. Page, I have annexed her identity card. Page 13, Lordship. 13 and 14, your Lordship will find circle officer, Shahpur, Bhojpur, Lordship. Ara district, Bihar, Lordship. She is also a government officer. She gave birth to a child in the year 2022. That document also, birth certificate also I have enclosed along with this as annexure to page 16.
In this case, Lordship, the learned trial court has passed an order that is Annexure 5, page 70. Page 70, 70. 70. Relevant portion, page 74, Your Lordship. That judgment which I have cited just now, Lordship, it was only quashing was done to the respondent sister-in-law only on the ground that they were resident of a different district, Lordship. Similar to the facts of this case, Lordship, this respondent petitioner number 4 is also a resident of Bihar. Until date, she has not yet, Lordship, come to Assam to see her own sister-in-law, Lordship. And as such, Lordship, the order which was passed by the learned trial court, Your Lordship will find para A, B, C, D, and E. These are her prayers, Lordship. And later on, the trial court directed upon perusal of the applications, page 75, Your Lordship. Upon perusal of the applications and the documents submitted by the aggrieved person, in prima facie appears that the aggrieved person has no independent source of income of her own, and that the respondent number 1 is a doctor by profession and earns a monthly income of rupees 1.50,000. The aggrieved person has paid for an interim maintenance of rupees 50,000 per month. However, the aggrieved person has not furnished any document to substantiate the fact of income of the respondent number 1. In absence of anything to the contrary, it can be presumed that the respondent number 1 is an able-bodied person at the time. At the same time, it cannot be denied that the respondent number 1, being the husband, an able-bodied person, is liable to maintain his wife. Hence, the respondent number 1 is directed to pay rupees 8,000 per month as interim maintenance to the aggrieved person. So interim maintenance was granted along with, Lordship, his bank accounts and also where, Lordship, he was not allowed to operate his bank accounts, Lordship. As the prayer was made by the aggrieved person not to allow the respondent to operate the bank accounts, Lordship. Where it is granted? Lordship. No, it's not there. Lordship. It was there in the order itself. There, Lordship, I have seen. It's a very big order, Lordship. 8,000, I am not disputing. I am ready to pay 8,000 per month, Lordship. Okay, here only issue notice for you. Lordship. But only, Lordship, this order may proceeding may be stayed. No. Subject to payment of 8,000 per month, Lordship. No stay will be there. Only
I'm
issue
ready
notice
to
for
pay
you.
the 8,000 amount.
Issue
Lordship.
notice, text it within 4
But
weeks.
Lordship,
Other one,
cannot pay
I'll just elaborate your
Lordship.
condition. That's why I thought that it was,
Lordship,
but maybe it's not possible.
Obliged.
4 weeks.
26. The LCR may kindly be called.
Yes, we are calling for this. Can
Lordship,
copy of the
okay.
LCR, we are calling.
Lordship,
Issue notice to the respondents and it will be fixed after.
Lordship, obliged.
My lord, this is a quashing petition, my lord, for a complaint case where cognizance has been taken in the most mechanical manner, my lord, without assigning any reasons. My lord, the FIR, my lord, just before I take the lordship to the complaint petition, my lord, I'll just give in nutshell, my lord, a background of this case, my lord. This is what happened, my lord. There are two adjacent properties. Now, my lord, the petitioner before your lordship, their predecessor in interest, my lord, had taken on lease a part of the land of the complainant, which belonged to the complainant from their predecessor in interest, my lord, and a lease agreement of 35 years was executed, my lord. Now, my lord, the complainant, they don't want to extend the lease deed. Now, my lord, we had filed a civil suit. A civil suit is pending before the court. They want to make an illegal construction over
over the said building. We filed an injunction petition under Order 39. The court granted an injunction in our favor. Those are everything is there on record, my lord. Now, my lord, they filed a complaint alleging inter alia that, my lord, that we had, while they were trying to construct the building, we had used filthy language and we tried to restrain their worker and all this, my lord. 506, 341, 504, and 294. Complaint petition was filed. Now, my lord, the complaint petition prima facie does not disclose any of such ingredients, my lord. This is my first. Second, my lord, out of these sections, some are cognizables, my lord. Now, my lord, they don't exhaust the remedy under 156, that don't file FIR, and all this, they straight away come to court without exhausting the remedies, my lord. Now, my lord, will kindly see the complaint petition at page number 29. I'll not bother your lordship with the entire narration of facts, my lord. I'll just take your lordship to the relevant part where they allege this intimidation and everything. Page 29, my lord, is the complaint petition. My lord, may kindly come to page 32. These para 7, 8, and 9 are the allegations, my lord. My lord, they say that on such and such at 3:30 p.m., the accused number 1 and 2 suddenly appeared in the terrace in the building and created obstruction in the repairing works of the shed, and they brought other accused person to their help, who are their employees and security guard, and with their help, they started abusing laborers engaged by the complainant for repairing of the shed. And when the complainant intervened, all the accused started using filthy language and misbehaved with the complainant. Let I take a pause here, madam. What language used? What was uttered? Nothing mentioned. This is a requirement sine qua non to, they must specify. Because this vague statement will not do, my lord. There is a clear-cut judgments of the Supreme Court, my lord. Then they say that the husband of the complainant was also present at the relevant time when the accused person trespassed and used slang language and used criminal force. Criminal force with the complainant. The accused of force started throwing stones suddenly in order to cause breach of peace, and situation of unpleasant environment was created by them intentionally to harass the complainant and the family member. Para number 8, save and accept they are using the word threatened with dire consequence and want the complainant to stop the work. Para 9, they are using the word wrongfully restrained and insulted. My lord, these are the words picked from the law book, my lord. My lord, we kindly see that the injunction order which the court has granted in our favor is at page number 103. Formal party 103. This is the injunction order. This is between the petitioner and the complainant. The operative part is, I take a lordship to the operative part at 107. The last para. Accordingly, the opposite parties, their man, agent, employees, workmen, or anybody claiming through them from carrying out any construction above the 4th floor of the building situated on the land described in Schedule A till disposal of the main suit, number TS, number such and such. The observation made herein are only in order to decide the aforesaid petition, will not have any bearing on it. There was an injunction also in my favor. So there are civil disputes pending, my lord. Now, my lord, the lease deed, my lord, which they have executed with us, their predecessor in interest, is at page number 110. I am just indicating all this. I will not go much in detail to show that it is a property related matter, purely out and out civil dispute, which they are trying to give a criminal color without there being any ingredient of all these sections. Page number 110. The lease deed starts from 108 and 110 I'll just take your lordship to para number 3 to show that it was an understanding between the predecessor in interest of both the parties that after 35 years, the lease shall be renewed. So this is where the problem is, my lord. They are not related. My lord, that's not the issue here, my lord. I'll just indicate one para. 2023, latest. 2023 to this one. 2023, 23 to this one. 2023. I do not. Muhammad was the Muhammad was it? Yes. MS. Muhammad was it? NS. Yes. My lord will kindly see. Squarely covered. My lord may kindly come to para 7. Here also the allegation was that she has used unparliamentary words and 294 was attracted. The Supreme Court says at para 7, internal page number 821. It is to be noted that the test of obscenity under section 294B IPC is whether the tendency of the matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences. The following passage from the judgment of the court has quoted some other judgment. Your lordship may skip it, para 8, that the exact words utter has to be there. It has to be noted that in the instant case, the absence of the words which will involve some lascivious element arousing sexual thought or feeling or words cannot attract the offense under section 294B. None of the record disclose the alleged words used by the accused. Then para 11. The complainant also, because 341 is also here in this case, similar type of case, my lord. Para 11. The complainant also failed to disclose the necessary ingredient to constitute the offense of wrongful restraint in order to attract application of 341, which provides for punishment for wrongful restraint. It has to be proved that there was obstruction by the accused. Such obstruction prevented a person from proceeding in a direction to which he has a right to proceed, and the accused caused such obstruction voluntarily. The obstructor must intend or know or would have reason to believe that the means adopted would cause obstruction to the complainant. Para 13. This is important, my lord. Para 13. Taking cognizance of an offense under 191 CRPC and issue of process under section 204 are judicial function and requires a judicious approach. This is a proposition not only based on sound logic, but is also based on fundamental principles of justice, as a person against whom no offense is disclosed cannot be put to any harassment by the issue of process. Issuance of process must be preceded by an application of judicial mind to the materials before the court to determine if there is a ground for proceeding against the accused. Para 14. When the allegation made in the complainant are found to be too vague and general without giving any material particulars of the offense alleged against the accused, then the order of the magistrate issuing process on the basis of the complaint would not be justified, and there must be material prima facie for issuance of process. We have our own doubt whether even the verification of the original, accordingly the entire proceeding was quashed. Now, the application of judicious mind, my lord, will kindly see the order of cognizance which your lordship will find at page number 39. Nothing. Page 39. My lord is there. Complainant is present and she is examined under 201. Farida Nasin, her sister, complainants, has been examined 202. They are discharged accordingly. Heard the counsel for the complainant, peruse the case record, considering the material on record, cognizance taken. not even one liner as to how she has come to the finding that.
State your is formal party, I think.
Yes, formal party.
There is a formal party, madam. Only, madam, I'll say, madam, about the order taking cognizance, madam. Madam, what the trial court has committed wrong, my lord. After examining the, my lord, complainant witnesses, my lord, trial court has two cognizance, my lord. Trial court has not framed charge or offense has not been explained, my lord. Only, my lord, cognizance taken. Now, my lord, is there anything wrong of the trial court, my lord? Whether, my lord, after examining the, my lord, complainant witness, can a trial court, my lord, cannot take any cognizance, my lord?
It's not.
It is the duty of the trial court to take cognizance, my lord. So whether, my lord, is, my lord, the charges frame or, my lord, offense is explained, that is a different aspect of the matter.
My lord, this is a complaint case, my
So,
lord,
my lord,
charge frame state.
definitely.
Perhaps
Charge
my
not
friend,
framed, but
my-
offense will be explained, my lord.
it to
Offense will
complaint
be
case.
So, my lord, at this time, notice may be issued, my lord, and let the opposite party appear, my lord.
My lord, because on 24th the day is there, I have prima facie shown, my lord, that no offense is attracted, and prima facie, my lord, this order is not my lord, falls short of what Supreme Court has contemplated. There are, this is the last day of the court. I don't want to bother your lordship with other judgment. There are n number of judgments which says that cognizance order must reflect application of mind. There is one judgment which says that merely the line that I have perused the record will not satisfy the test. That I have perused the record will not satisfy the test.
Mr. M. Biswas, Iran counsel for the petitioner. Also, Mr. R.J. Burwa, Iran additional PP appearing on behalf of state respondent. This is an application under section 528 of BNSS for quashing the complaint case number 427 of 2023, and also challenge the order of taking cognizance dated 28/11/2023 by the learned additional CGM Kamur and Guwahati. Issue notice to the respondents. No formal notice is required to be served on so and so. Next, I also call for the scan copy of the LCR. Next, it is submitted by Mr. Biswas that there is a civil dispute between the parties only for an lease agreement between the predecessor in interest between the parties, and on the basis of which the petitioner also filed an civil suit. An injunction is already obtained against the respondents. Respondent number 2. Further, he submitted that from the ingredients, the plain reading of the complaint, it is seen that the plain reading of complaint also does not fulfill the ingredients of section 294 or 443-41 IPC, under which the cognizance will be taken.
There are two more sections, 504 and 506 and 352.
Ingredients to fulfill the ingredients of section so and so, under which the cognizance was taken by the learned court below. More so, there is no application of mind while passing the order of cognizance, and it's a mechanical order has been passed taking cognizance against the petitioners. Accordingly, has submitted that if further proceeding against the present petitioners may be stayed till the disposal of the present petition. In that context, Mr. Burwa, the learned additional PP, submitted that there is no illegality has been committed by the learned trial below while taking cognizance, and the cognizance was taken after perusal of the complaint and recording the statement of the complainant as well as the witnesses under section 202 CRPC. Accordingly, he insisted to call for the scanned copy of the record. Next, hearing the submission. For the he will stay till next date of listing. State till next date of listing.
Also declare that. I'm grateful, man. All is well that ends well. We were the last case before vacation.
I'm sorry, Lordship.
4 weeks.
I'm sorry, Lordship. In
earlier item 25, Lordship, page 74, their order was there, withholding the operation of all the bank accounts, Lordship, by all the respondents, and I was not able
Listed
to.
after 4 weeks, we'll see to it.
Chief, that part can be modified, otherwise I may not be able to pay the amount. All the persons, Lordship, respondent number 1 to 4, namely Parvez Alam, Tahir Hussain Ansari,
There may be some reasons why all the bank accounts were in fact freezed. Without
Lordship,
hearing the other
DB
side, it cannot be.
case, Lordship, or Lordship, liberty may be granted to file an application before the magistrate to modification of that part only, otherwise. This
So no,
part
it is time now. There's no time.
applies, Lordship.
27.
May plead. But in 2019.
Hmm?
In 2019, the informant. So.
Yes.
Maybe. I think in 2019, 2019, the informant, page 40. It starts from page 38, the original copy. I am showing the original copy. Page 40. I, Malati Chaudhary, my car Hyundai Accent, number so and so, color so and so. That car is took from me by Sanjeev Singh for his personal use, and he did not receive my call for the last 3 days. I gave him my car at his office, Mahabahu Solution ABC Bhagar. I requested to please search my car and kindly hand over to me. Lordship, this is the details. This is filed on 2/11/2019. Now again on, interestingly, Lordship, again Lordship would see page 21.
2/11/2019.
19. Now at page 21, Lordship, the same informant, this is given in Bhangar police station, the earlier FIR. Now the same informant on 23/11/2019, page 21, files another FIR. Page 19 is a translated copy.
Page?
Page 19.
19. Malati
Chaudhary, residing near Charmani, Vedic school, has the honor to say that on 3rd April, the boy named Anjan Sharma, a resident of Pioli Fukon, Krishnanagar, took my Honda four-wheeler, bearing registered number A01DZ4843, the same, on rent at monthly rent of 21,000 by executing a bond agreement, but he has not paid the full rent in any month. I have became tired of asking the rent. Still, he has not paid the rent. Rent an amount of 21,000 for October 2019 and the amount of rupees 21,000 for November to me. I have asked to return the vehicle, but he has not returned the vehicle, and now he even does not attend my phone calls. I have become unable to pay EMI to the bank. The same car, same vehicle, 2 FIRs, without informing the Sanmari police station that she has already lodged an FIR in Bhangar police station on second.
The second is in Sanmari. Other was in Bhangar.
No, second is on Bhangar.
No. Second is on Sanmari.
No.
First one is of Bhangar.
Bhangar. Yes, doctor. I'm sorry. Now, this FIR, the court searches this file. The court takes cognizance.
In both the FIRs?
No, in another charge sheet is not. In this 20, the second FIR 23rd. Now we brought to the notice for the first time at the stage of consideration of charge, before the consideration of charge, there is another FIR in the Bhagar police station. Now the Honorable Court calls for the record of Bhagar PS. On a subsequent date, we also produce a photostat copy. I will show the order sheet. The Honorable Court takes note of the same. Now, without receiving the records of Bhagar police station, now charges have been framed. And Lordship, charge framing order is under challenge at page 32. Initially, the FIR was filed in 420 and 406. Now 4020 is not there, only 406 is there. And I will read at page 32. (32) is a type copy. Firstly, that you on 3rd of April 2019 being entrusted with a vehicle of the informant bearing number so and so, which was given to you on rent with a condition that you will pay 21,000 per month to the informant, but initially paid a rent amount to the informant very irregularly and stopped payment completely, and also you converted the said vehicle for your own use by not paying the rent of the vehicle to the informant, and that you have committed offence punishable under 406. Look of it.
Where is the
shows-
order when the report from Banagar was called?
Yeah, yes, Lordship. That only from page 41, Lordship. Lordship would kindly see annexure 5 to 24 past 30. 41, the accused filed a petition. 41, page 41.
Yes.
Bearing number so and so paid for calling for records of CR Bhagar PS case number 503 stated therein. That is the first order. Second is 42, Lordship. Today is fixed for hearing the petition 3385, wherein the accused side has paid before the court for filing FIR of Bhagar PS 503, stating the reason therein to substantiate his plea. Learned counsel for the accused has submitted a photocopy of the FIR in connection of Bhagar PS. I have perused the prayer and also heard the learned counsel of the accused as well, considering all prayer made, call for FIR from the OC Bhagar in connection with Bhagar PS, inform accordingly. Now again, Lordship, we did 611, Lordship, 23, 24, yes, excellent. 611 at page 45, Lordship. 45. No report received till yet. Learned counsel for the accused has furnished photocopy of the certified copy of FIR Ejahar Bhagar PS 503 white petition so and so. Again, Lordship, however, at page 50, formal charges under 406 by order dated 27/5/2004 has been framed. Firstly, Lordship, if Lordship looks at the page 32, it looks like there is an agreement, there is a non-payment of rent. It is purely a civil list. That apart, Lordship, we have already given the certified photostat copy of the certified copy. The Honorable Court has called for it. But now, without receiving the report, Lordship, this charge have been framed, Lordship. If some reasons were given for not accepting, some application of mind was there in non accepting the Bhagar PS, that was a different thing, Lordship. But absolutely, when we have produced the photostat copy of the certified copy, even the FIR, Lordship, some application of mine was required while charges was framed, Lordship. Therefore, Lordship may issue notice, call for the record. In the meantime, this case may remain state, Lordship. proceedings may remain state. That is my humble prayer.
My lord, it is such that case, my lord, and such sheet has been submitted, my lord, on the basis of my lord Sanmari police station case number, my lord. That is the my lord first FIR, my lord. Now, my lord, yes, my lord, challenging just framing of search, my lord.
The first FIR is
First FIR, my lord.
first
it is
FIR is on 211. That is
211.
Banagar.
Yes, page number, no, my lord, it is Sanmari, my lord, page number 23.
No, no, the
Page
concerned
number
case is of
37.
Sanmari, which is the subsequent FIR in fact.
My lord.
First FIR was of 2/11/2019 before Bangagar.
Bangalore PS, my lord.
Page
And
40.
then
But my
one,
lord, the
other
FIR,
one,
second FIR, my lord, search is submitted, my lord.
yes.
The second FIR, first FIR, my lord, search has not been submitted, my lord. Now, my lord, on the basis of that FIR, my lord, second FIR, my lord, taking my lord, my lord, private facie materials are found, my lord, that is why my lord, searches have been framed, my lord. Now, at this stage, my lord, notice may be issued, my lord. Because searches have already been framed, my lord, this search case, my lord.
May please, your lordship.
And he is not challenging the, my lord, FIR, my lord. He is not challenging, he is challenging the entire
Proceedings I have
proceeding
challenged,
and
entire
as well as the my lord, order framing search, my lord. Because if he has challenged the my lord FIR, my lord, then it would have been different, my lord. Because there are two
That
FIR in that
challenge
case,
is
my lord.
not there.
Yes, my
No,
lord.
proceedings,
He is-
entire proceedings are under
Let me
challenge.
complete it. He is challenging, my lord, the order, entire proceeding and the order framing search, my lord. My humble submission, my lord, this is a case, my lord, where search has been submitted, my lord. That means there are prima facie materials against the accused person, my lord. And on the basis of that materials, my lord, the learned trial court has framed search.
May please, your lordship. The earlier 482 and now 528 has been framed with a particular object, lordship. It's an inherent power. When the court sees that someone has fraudulently abused the process of the court or for the interest of justice, this power is exercised. This case, the informant has not informed the court and the police that earlier an FIR was filed, lordship. This case particularly falls under the abuse of the court process, lordship. And moreover, we have challenged the entire proceedings. And moreover, what is there, we have already mentioned about the FIR. The records were called, lordship. It was, lordship, it was there to wait for the records, lordship, because and the search framing, lordship would see at page 32. There is no mention about the FIR. Therefore, lordship,
Understood, yes.
So let notice be issued, my lord, asking copy may be called for, my lord, that the opposite party appear, my lord. Therefore, my lord, the matter may be harsh.
Hi, Mr. Oh. Hi, Mr. B.P. Bora, the learned counsel for the petitioner. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section 528, so and so. Praying for washing of the impugned PRC case number 1481 of 2020. And the order of framing charge dated 21/11/2020 by learned additional CGM Kamrup M. Under section, your charge was framed under section 406 IPC. Though the case was earlier charge sheeted on under section 406/420 IPC. Issue notice to the respondents. No formal notices to that. Mr. Bora further submitted that the present respondent number 2 earlier lodged an FIR before Bangagar Police Station on 22/11/2019 for the same vehicle, alleging that the present petitioner took the vehicle for his personal use and did not return. But subsequently on 23/11/2019, another FIR was lodged before Chanmari Police Station with some other allegations. And on the basis of after investigation, the case was charge sheeted against the present petition. Where at the time of framing of charge, before framing of charge, the one petition was filed before the learned court below, praying to call for the case record of Bhangagar PS case diary of Bhangagar PS case number, Bhangagar PS, and that was also, the prayer was also allowed, and the learned trial court below also called for the case diary of from Bhangagar PS. But without receiving the case record of the case diary from Bhangagar PS, the charge was framed when?
27/5/2024.
Without even receiving the case record and without applying any judicial mind. The same has been framed. The charge has been framed against the present petitioner under section 406 of IPC. Accordingly, he submitted that till the disposal of the present petition, the proceeding in the case proceeding of the present case number so and so we state. Mr. Borwa, the learned additional PP, submitted in this regard that in the present case, the charge sheet has already been submitted and charge is already framed by the learned trial court below. And hence, at this stage, only notice may be issued calling the as scan copy of the LCR. He further submitted that there is no prayer for setting aside or quashing of the FIR or the charge sheet, and only the order of taking cognizance and the proceeding was challenged and prayed for quashing of the same. Next paragraph, considering the entire submission made by learned counsel for both sides. Stay report till next date of listing. List after 4 weeks. Okay, it will be stayed till next date of listing.
Deeply applied.
28.
Time is over almost. Yes.
Uh,
Say AB.
AB might have NDPS, but I just for your loss can have a look.
NDPS.
NDPS, but I am not my lord. My name is not there in there. Just you can look this paper, my. It will everything make clear, my. The vehicle in possession of the petitioner. You will kindly see the number, chassis number, engine number, name. Your lordship. Vehicle seized. Next, my lordship. On 9/9/22 at Cognizance. Only problem is that this vehicle number is same. Chassis number all are different. Different. Now my name is there. Now my name in the that my seizure listed name is there. Rajpal Singh, my lord, Punia. Now what happened, my lord? In the first charge sheet, your lord kindly see, my lord, first charge sheet, page 44. My name is not there. FIR, my name is not there. First, my lord, one person, driver is arrested. He is from Bihar. Vehicle is, my lord, seized at Cognizance. Driver, I do not know driver who is the driver also. I have no connection at all. I have never visited Cognizance. My car has never come to Cognizance. Now, kindly see, my lord, page 44. I will not take much time, my lord. 44. Annex 10, my lord.
Yes.
This is the first charge sheet, my lord. I take your lordships to page 48, your lordship. Page 48. Name, my lord, Manish Kumar. He is the driver of the vehicle. And your lordship will find page, my lord, 42. Sorry, seizure list. Name of the vehicle, number of the vehicle, 42.
40?
42. Your lordship kindly compare the note I have given and the number it is there in the page 42, seizure list, your lordship, seizure list. See the description of the seizure articles, my.
Yes.
Your lordship see the number kindly registration number, chassis number, I have given kindly check, my lord, which was seized. Same, my lord. From this, I have noted, my lord. So my car is not, vehicle is not coming, my lord. Next, first charge sheet, I have said, my lord, you will kindly come to pay 48, name of the vehicle, that is driver is there, Manish Kumar. Then your lordship will find, kindly come to page 52, story. (52). Here, madam, nothing about me. My friend is here, madam. Nothing. I am speaking, madam, oath, my lord, before your lordship, madam. I am not taking your lord. Nothing. Only next page, your lordship, kindly see. Next page, 53. First, second paragraph, my lord. However, your lordship got it, madam. However, this charge sheet may be treated as part of in nature, and a supplementary report along with a CD shall be submitted to the Honorable Court once MBI report from DTO coming on in respect of actual owner of the seized truck bearing registration number so and so, as well as the secret chamber inside the truck is received. So this is matter on 30. This was dated 30, matter for 30/11/22. This part first. You kindly note that is important. 30/11/22. Then kindly see page 54, supplementary charge. And the final charge was page 54. This is dated, my lord, 6/3/23.
Yes.
Page 54.
Yes, 54.
Date your lordship, my lord, first, second column, supplementary report number 164, capital A 22, dated 6/3/23. And earlier one was 30/11/22. Your lordship got the point.
Yes.
Now come to my lord, kindly see that story, my lord. My name, page 58A. 58, my lord, type copy I have given, 58.
Yes, 58A.
At the time of inspection, the vehicle was found mechanically in a good condition. But if my examination is noticed that there is a number of special, one chamber was the second chamber where ganja was kept. So here name and particular of the accused, Rajpal Singh, without saying anything, not a single whisper in the whole supplementary charge sheet against him. Not a single whisper. Simple name is given, and your lordship kindly see page 66.
66.
60. No, exactly same language, my lord, which was there in that case, first time, not a single, neither one word is less nor more, my lord. Same thing, my lord. Nothing against me. Now, only because that name was given, somebody kept a fake name, my lord. Because of that, this tax is given. And thereafter, your lordship kindly see page 62. Supplementary charge sheet is given, and NBW was issued. Without anything, my lord, without talking. 62. Accused person Manish Kumar is produced from the jail. Accused person is so and so. On perusal of the case record, it is seen that a supplementary charge sheet has been submitted against the absconding. Where is absconding? Nowhere they have stated absconding, my lord. In all the papers I have given, kindly my honored friend will see not a single one. Because he is not named in the FIR. The question of absconding does not come, my lord. So now they say absconding accused, in view of the above, issue NBW against the absconding accused. So that I am appearing. Nothing is there, my lord. It is not a case of my lord at all, my lord. There is my lord scan copy of the charge sheet, my lord. This may be called for in the meantime, you also can be protected. Nothing is there, my lord. These are the case where your lordship makes your lordship discussion the power, my lord. Subject of my learned friends. I hope you will be reasonable one, my lord.
My lord, in this case, my lord, the commercial quantity of ganja was recovered and seized, my lord, from one Manish Kumar, my lord.
Yes.
And the vehicle number is, my lord, RJ so-and-so, my lord, that is matching with the my lord, vehicle of the petitioner, my lord. Now, what happened, my lord, during investigation,
No,
my
that is
lord,
not missing.
no,
it will match.
it more curious, my lord, during investigation, my lord, police investigating officer has submitted the search sheet, my lord.
but with a prayer to my lord, do the further investigation, my lord. In the first, in my lord, search it, my lord, this Monish Kumar, he has been implicated as an accused, my lord. The search is submitted, my lord. Thereafter, my lord, again, my lord, investigation was done, my lord, because the my lord, report of the DTO was not received, my lord. Then, my lord, after receiving the DTO of report, my lord, then the my lord, second search it was submitted, my lord. But now, my lord, implicating the my lord, the owner of the vehicle, my lord. Now, what my learned senior friend has stated, my lord, that vehicle registration number is same, my lord. But engine number and chassis number are different, my lord. Now, my humble submission is that, my lord, since it is a search case, my lord, he cannot appear before the police, my lord, because investigation has already been completed, my lord. And what I am only on, my lord, on one point, my lord, the learned trial court had, my lord, on the very first stage, my lord, NBW has been issued, my lord. But that, my lord, subject to my lord, correction, my lord, Interim one subject case, my lord. At the very first stage, my lord, package cannot be issued, my lord. NBWA cannot be issued, my lord. So, my lord, what he have to do, my lord, he cannot, my lord, go and appear before the police because its investigation is already completed. Now, what he will have to show, my lord, all the documents, my lord, stating that his vehicle is not the vehicle from which the vehicle, my lord, the contaminant is recovered, my lord. That, my lord, he have to produce before the learned trial court, my lord. This session court, my lord. So, this is my humble submission, my lord.
But once I appear, my lord, I'm ready. Once I appear, unless your lordship allows me to go on bail, my lord, I will be taken to custody, my lord. I'm ready, my lord. Everything is. Fast tag is, my lord. Page, my lord, next 13.
Bail in a sense, only this observation can be made here. And court, apart from that, court may also be directed to make an inquiry regarding that, and till his appear before the learned trial court, his LBW may be suspended. That much only it can be given. Otherwise, bail cannot be given. He's suspended because he took a plea that the name is same, the registration number of the vehicle is same.
But engine number and chassis number are different.
Are different. But the question is that I don't know at the time of seizure, because engine number and chassis number you see, there are lots of yes, there digits are a big thing. So there may be I don't know by recording.
One thing just my subject to my learned friend, my fast tag, my lord. During this period, my car there, my page 60, you kindly have a look to page 87. First,
First 2, 3 digits are same. You see, 2, 3, 2, 4, 3 SR.
That is Rajasthan. That is from Rajasthan, man. This vehicle is from Rajasthan, man.
No. I'm comparing these two.
Yes. Rest
from 2, 3 digits are also same. In fact, there are maybe in the later part, their digits numbers may be.
Yes, 10596 or one.
That is the only issue. So
5
much
to
only can be given. Otherwise,
My humble submission, my lord, he cannot appear any produce the documents to the police, my lord. Because police has already been completed investigation, my lord. Now he will appear before the trial court, my lord. And he will have to, my lord, show that the vehicle is still in my possession, my lord, and the vehicle from which the ganja has been seized, my lord, the contaminant has been seized.
But vehicle is your position.
My vehicle is in my possession.
This you're still in your position.
Is still in possession, my lord. And that vehicle is in custody police, my lord.
Huh?
The seized my vehicle in his custody, in the police custody, man.
But your vehicle is
my vehicle with me. And you're kind of interested in 87, page 87. I'm giving fast tag, my vehicle is going on. I'm running in my car there, my. That is why I am before lordship. My car is still today, my it is with me, my. Just my 87, page 87, your kindness, only one. The chance shares now, my dear. Yes. Your lordship, first tag your lordship kindness, my lord, page 86A. First tag, 86A. First
tag is there.
Yes. Kindly say, my second, third line, statement bank period 1922 to 3922. At that time, 1922 to 30922.
And the incident?
Incident 99.
Huh?
9922.
99.
Then thereafter, other dates are also there, madam. Next, all the pages, first tag, till today, madam, it is there. My vehicle, I am running here till today, madam. And this car is here at Cognizance. So, my lord, I think it is a case, your lordship, your lordship.
Regarding my lord, the owners of the vehicle, my lord, it is, my lord, the accused has to prove before a trial court, my lord.
That's
That the vehicle is still in my custody, my lord, and the vehicle which was, my lord, seized and, my lord, contraband recovered, it is not my vehicle. I am only, my lord, submitting that, my lord, in the very first stage, my lord, NBW cannot be issued, my lord. There is a, my lord,
the
no
legal
one
point,
should be
fairly
given
he
my
submitted, I am not.
my fault.
My one appearance, I may be allowed to go on bail. The rest I will share everything. Otherwise, my lord, I will be prejudice, my lord. Not for nothing, I will be.
If
put to custody.
NBWA will, my lord, suspend, then, my lord, it will not, my lord, hamper.
Thereafter,
That
proclamation.
doctor, will direct the learned court below also to make an inquiry because
Yes,
as you
yes.
have submitted,
That should.
your car is this.
Only in
the
the
vehicle
meantime, what
is
will
still in
happen?
your position, in fact.
What
So
till the inquiry is made, my lord, I may be protected. That is my, I am not asking for blanket order, my.
Mr. H.I. Chaudhary, the learned senior advocate, assisted by whom?
I, Haduriko.
Huh?
I.A. Haduriko.
I.A. Hajurika, the counsel for the petitioner, and also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent. This is an application and section so and so in connection with so and so. Full stop. It is submitted by Mr. Chaudhary, the learned senior advocate, that the present petitioner is no way connected in the arrest offense. The charge sheet, and the one vehicle was intercepted along with some contraband, and accordingly, the driver of the said vehicle was arrested in connection with this case, and charge sheet was accordingly submitted, wherein there is no mention about the involvement of the present petitioner. However, there was a prayer from the IO to file the supplementary charge sheet on receipt of the MV report. Accordingly, the supplementary charge sheet was filed on 6/3/2023, showing the name of the present petitioner as an absconder. Though there is no mention at all as to how he was involved in the alleged offense. Further, he submitted that the vehicle which was seized in connection with this case, the registration number of the vehicle which is seized in connection with this case is similar to the registered vehicle of the present petitioner. However, the engine number and chassis number are different. But without making any inquiry into that regard, the charge sheet was filed against the present petitioner, showing him as an absconder. Further, Mr. Chaudhary has submitted that the vehicle bearing registration number RJ10GB6442 is a truck.
10-wheeler.
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 Chassis number, my lord. Otherwise.
No, it's okay. 10-wheeler is still under his position.
Yes.
And it is
That has a stock.
still running with the goods. More so, the Alice incident had taken place on 9/9/2022, wherein a first tag of this vehicle continues from 1/9/2022 to 30/9/2022, and the vehicle is still in his position. First. More so, further he submitted that the NBWA has been issued against him by the learned trial court below on the first date of the receiving this supplementary charge sheet. Full stop. However, the present petitioner is ready to appear before the learned trial court below if some interim protection is provided to the present petition. Full stop. Next para, Mr. Borwa, the learned additional PP submitted in this regard that it is a fact that on the first day of receipt of the supplementary charge sheet, the NBW was issued against the present petitioner, and in the same time it is also submitted that from the engine and chassis number provided by the learned counsel for the petitioner, it seems that there is difference in the engine and chassis number are different from the vehicle which was seized in connection with this case. Accordingly, he submitted a direction may be given to the learned trial court below to make an inquiry in this regard. As the case has already been charge sheeted, the petitioner cannot appear before the IO at this stage. Next paragraph, considering the entire facts and circumstances of this case and all the relevant documents produced before this court by the petitioner, I find it justified to suspend the NBW issued against the present petitioner till he appears before the learned trial court below. And further, the learned special judge is also hereby directed to make an inquiry in regards to the vehicle which is seized in connection with this case, and whether the vehicle which is seized in connection with this case is similar or the same vehicle for which the petitioner is claiming his ownership. With the observation, you can we are directing the learned trial court below to make an every observation. Observation is made that the chassis and pages number are different. So you produce all the relevant documents before the learned trial court. It will make an inquiry. Until then, your NVW is stayed or suspended.
NVW subsequently proclamation also, PNA also issued, subsequently.
PNA issued?
PNA also issued subsequently.
Oh,
11, my lord.
2611.
11.
2611 PNA is also issued.
Next date is fixed.
If you know all these things, why you waited till your issuance of PNA?
No. I have never received, my lord. Problem is Cognizance in Rajasthan, my lord. I was not accused at all, my lord. Neither in the FIR, nor in the first charge sheet. No here, my lord. He is not there at all, my lord. Only my name they have found when the vehicle number is the same.
You are from Rajasthan?
Rajasthan. My vehicle never come here, my till today vehicle is with me. They are passing order every day, my.
Out of paragraph লগাই দিব সেইটো আপোনাৰ PNA টো stay কৰি দিব আৰু এটা লাইন কোৱাত এড কৰিব দিব the petitioner never received any notice, warrant or from the investigating officer nor from the learned trial court below, as he resides in Rajasthan and his vehicle is your vehicle transportation is from where to where then?
All India permit. That I have written all India permit, but it has never come to Assam at any time. Northeast never come to Northeast, madam.
And his vehicle runs around in and around the India, but till date his vehicle never reached to Northeast oblique Assam. To line to put milai dibo eta line. Okay then, please.
Lordship has not provided interim, madam.
Pardon?
Lordship has not provided interim protection.
Only interim protection is there, otherwise this petition is disposed of.
Madam.
Because what to do? We are not in a
position. But in a case of madam, PNA, madam, anticipated bail cannot be granted.
No, I am not on that here.
We are not, anticipated bail is not granted here. Just we are suspending the PNA, execution of the NBW and PNA.
That will do, my lord.
And he will appear, inquiry will be made accordingly. And the necessary order will be passed by the learned trial court below. We are disposing the matter at this stage.
I will produce all the records.
Yes, all relevant documents you appear. Because I have mentioned all these things.
That your lordship mentioned. I will
Yes,
produce
I'll
everything, man.
Every documents you produced, because we have already marked that these documents are no.
Madam, sorry to interrupt, Lordship. Lordship, I beg to item number 53, Lordship. In that case, Lordship, I have filed a miscase in a criminal appeal. And the court permit us to lease this matter, Lordship. We made a mention before the senior bench, Lordship, because the bail is continuing to till 23rd of this month, Lordship. Because conviction is for 2 months. So, Lordship, before rising, Lordship may take up this matter.
Oh, I'm rising only.
Item 43, Lordship.
What kind of order was there?
It was a conviction, Lordship, for 2 months.
Bail was continuing means?
Bail before the trial court, bail granted for preferring the appeal, Lordship.
And your date is tomorrow?
on Monday, Lordship. Till, I think it's valid up to 23rd, Lordship. That is why, Lordship, we have filed a IA that may be considered till disposal of the criminal appeal, Lordship.
No, but disposal of the criminal appeal was not the order, I think.
In criminal appeal, she was convicted, Lordship. For
No.
2 months.
The London court below passed an order because there is an order.
There's an order.
They
Yes, in IA, Lordship.
But that till the filing of the so and so, your petitioner may be on bail or what.
Lordship. I'm
That
right
will
now
be the order.
bail. I'm right now bail.
Ah.
Bail is valid up to 23rd, Lordship. After that, Lordship, again, Lordship, we have to approach before the trial court, Lordship, that may not consider.
We have lots of work, in fact. We are going, in fact, they are going. How can it be possible?
Only that
That's
this
a
I,
listed
Lordship.
only. Don't know why.
Take up the supplementary motions, my lord. I think 2 or 3 of them left the motions.
Kiba কিবা এটা আছিলে কি চাওকচোন কি আছে বাৰু এইটো মগজে কাম কৰা নাই
I 441, Lordship.
There are 2-3 motions left, whether my lord.
Yes,
I
will be
471.
after, huh?
Whether my lords will take up those 2-3
No.
supplementary motions left.
No.
My motions are urgent, my lord, because Zimma of a
It's okay,
very,
okay, then it will be,
will take little time, my lord.
no,
Whether my lord will fix it, my lord.
it will be after vacation. We cannot.
Actually, my lord, it's a genuine vehicle, so much.
Okay.
Only the motion matters, my lord.
83.
Where is the order of your bill?
Lordship. Page 83.
Goro, have you gone through this one?
Order.
Huh?
I'm going to stay to like.
Nice.
No, it's a POXO case, my.
POXO case, but
Oh, it's a POXO.
But
Yes.
kindly see the judgment, Lordship, judgment part regarding she was convicted for under section 509 for 2 months. Yeah, so. It is. It was, she was convicted on 5/12/2024, Lordship. That was again extended and we have annexed that. Till 23rd of.
Show me the order.
POXO case, my lord. How it can be, my lord?
POXO case, but Lordship, trial court already granted bail. It will extend more, no?
Order 925.
In the judgment page 69, Lordship, page number, paragraph number 39. She was convicted under section 509.
No, conviction is okay. Where your order is there that you are considering the bail still so and so.
5/11/2024. Then it was considered again on 5/12/2024.
এইটো order তেখেতক দিওঁ, বৰুৱাক দিওঁ।
My lord, my humble submission is that they have sought time not to prepare an appeal, my lord. Now they could not prepare an appeal within time, my lord. They are, that is why, my lord, they are filing the appeal today, my lord, and my lord.
We have filed on
No, we have already filed.
5/12, we have filed this petition, lordship. It was not listed, that is why we made a mention before the senior bench lordship, and accordingly, this honorable court has permitted us to move the petition before this honorable court lordship.
Okay,
And this is the order lordship, 5/11/2024 order is there lordship.
No, you have filed the appeal when?
When?
Appeal was?
Yeah.
Appeal was
It
filed
was
on 5/12.
Now, my lord, this Asma Begum, my lord, has been convicted for 2 months and pay a fine of 2,000 rupees. Sorry, 5,000 rupees. Well, appeal may be admitted, my lord, and my lord, she is already on bail, my lord.
Since well, that bail may be extended lordship,
No, your eye is for what?
for that lordship. For suspension of sentence and
Suspension of
allow me to remain on previous
Up
bail.
to next date of listing, she may be allowed to remain on previous bail. Next is suspension of sentence question will subsequently arise.
In the meantime, I can take the steps to the,
Because she is on previous bail till continuing, I think.
yes.
Bail is still continuing. That may be continued till,
He may be allowed, and my lord, he may be allowed to remain on bail, my lord. Suspension of sentence may not be.
no, suspension of sentence will not come.
Yes.
So should I pass the order in the I itself or in the?
My lord, in both the above, appeal have to be admitted, my lord.
First appeal, that may be admitted.
Appeal has to be admitted.
Appeal letter
The
আছে,
notice will not-
In appeal, lordship, admit the appeal first, then in I lordship, this order till the next listing lordship. For continuation of the bail lordship.
খালি লিখো appeal to admit কৰি দিব এইটো। Appeal admit কৰক, issue notice কৰিব, and also call for the LCR appeal list after 4 weeks. And in IA you write, this is an IA, you have to issue notice কৰিব for suspension of sentences. বাকি একো নিলিখিব, however, considering the submission made by the learned counsel for petition that she is still on previous bail, which is continuing. When the next date is fixed on?
3rd of December.
Yes, previous bail is still continuing till 23rd of December 2023. Accordingly, her previous bail may be extended till the next date of listing. And on receipt of, on appearance of the respondent number 2, the matter may be heard and decided.
And steps lordship regarding the respondent number 2.
Steps, both the steps to the additional police station, that will be understood. Stay. Your petition is extended till next date of listing. Previous bail is, but suspension of sentence will be heard on the next date of list. And BPL has been that we issued notice through jurisdictional police station related to the office of the public prosecutor. and registrar.
I'll take the steps in the meantime. But in the next date will be, my lord,
Next date cannot be given after vacation, it will become
after vacation, steps must have to go after
after vacation.
My lord, all the young friends, my lord, last day, they are a little disappointed. I said, cannot help it. Court has to perhaps.
Okay, then we cannot.
Only one prayer, my lord. In respect of item number 21, also kindly fix on 9th January. 12th January. 12th January, it will be difficult for us because there is a big vacation will be start. So 9th January.
Which one? 20?
29.
29.
Admission.
9 January.
9th.
39 on the 6th. 39 on the 6th.
You
I
don't
thought-
have any dates. Okay, 39.
And a happy vacation, my lord.
Thank you.
happy vacation and happy new year.
Okay, okay. Thank you so much.
No, all the motions, the leftover motions on 6, my lord.
Okay, we'll talk.